Lord.
Hmm.
Lord, I pick mention item number 30. I wanted to withdraw this matter.
You want to withdraw?
Yes, ma'am.
It's a delay application.
Delay petition with RS, my lord.
Why you want to withdraw?
My lord, new fact is started, my lord. It is the Tozi land. Recently, some third party entered into the land portfolio and occupied the land. That is the, my lord, the appeal against the government.
Then
That is why, my lord, we are going to file fresh litigation, fresh suit, my lord, to report the trial.
yes, Mr. Babudari. Come here, come here. Item number 30. You may not. The state of Assam is there.
My lord.
Now he says that this is an appeal which has come all the way. It was a Tozi land for the government. Now he wants to withdraw this and then file something else. What is this type of filing? What can you file now?
My lord, regarding possession, my lord,
What was the case for? Because you see, the liberty to be granted to you, I can't give you any liberty.
I am not paying any liberty. Because totally fresh cause of action, my lord.
What was held by the first appellate court?
It was dismissed, my lord.
You must have filed the suit.
My lord.
What was the suit for?
Suit for, my lord, confirmation of possession.
Against the government.
Yeah, against the government.
And the suit got against you.
My lord.
So nothing remained.
Nothing remained.
Mr. A.U. Ahmed, the learned counsel, appearing on behalf of the applicant, submits that the applicant does not want to pursue the instant application filed for condonation of the delay in filing the accompanying second appeal against the judgment and decree dated
Judgment and decree dated, my lord, 12/7/2019.
12/7/2019, passed in
Passed in, my lord,
title appeal
my lord, 9/2019. My
by
lord, by the civil judge, senior division, Golpara.
taking into
So, my
account
lord, the date of judgment, my lord, 3/2/2021, not 9.
3/2/2021.
Well.
Date of judgment. Taking into account the above, the instant application seeking condonation of delay is hereby dismissed on withdrawal. In that view of the matter, the accompanying appeal, which is now barred by limitation, cannot be entertained. Mr. R. Pudari appears for the state.
Obliged. I am obliged.
Yes, madam.
My lord, I beg to mention item number 3, my lord.
3.
Yes, my lord. Here, my lord, the engaged counsel is not available, Mr. SSD, my lord.
Huh?
Mr. SSD is not available. Moreover,
Madam, it's a 2014 RFO. Don't make a mention.
suit is fixed for
Don't make
hearing.
a mention about this 2014. 10
My
years have gone by.
The original suit is, my lord, fixed for hearing on the first week of June, my lord.
Whatever may be. I'm not going to adjourn any 2000. Madam, you are there? Then? If you want, I can make it in practice or whatever may be. Or you want to argue without your gown. You argue the matter. Without your gown, you argue. You want to argue. Madam, nothing doing 2000. No, madam, 2014 matter I don't adjourn. Sorry, please don't.
May please, Lord. My lord,
Item number 48. I want to.
Oh, you want to withdraw?
No, the other
Better
than
off.
yes,
Mr. A.R. Sikdar, the learned counsel appearing on behalf of the appellant, submits that he may be permitted to withdraw the instant second appeal directed against the judgment and decree
My lord,
dated
I have not. I have
item nutun file, the 48. Judgment and decree dated 30/10/2023 passed in title appeal number 11/2022 by the Court of the Civil Judge, Borbetta, Assam. Whose taking into account the above, the instant appeal therefore stands dismissed on withdrawal.
There is an I that.
So I stands closed.
Please, your lordship, item number 50, lordship. I am for the respondent, lordship. In the meantime, we have filed a stay vacate petition, lordship. Stay vacate petition IACV, lordship. I have filed, but that is not there in the list, lordship, today. I'm praying.
What is this IA 437?
And that is, lordship, there is an interim order against us, lordship. And that against that order, we have filed a stay vacate petition, lordship. And that is not there in the list today. My prayer is, lordship.
What is the IA number?
IA, lordship, filing number is there, lord. I have filed it.
Yes, what is your name? You have
Yes.
informed the other side?
Yes, lord, I have informed.
Okay. Your name?
S. Kanungo.
Ms. S. Kanungo, the learned counsel appearing on behalf of the respondent, submits an application for vacating the stay has been filed. However, the same is not on record. She submits that the filing number of the said application is
56 IA civil number 5 filing number 5634 of 2024. On
give it slowly. What is the number?
IA civil filing number 5634 of 2024, lord.
So taking into account the above, list the matter again on 5th of June.
Yes, Mr. Lordship. Lordship, I want to mention regarding withdrawal of the matter for tomorrow.
Not tomorrow, day after.
Wednesday.
Yes, madam,
May
what
I
you are
present, Lordship?
challenging?
Lordship, I filed a petition against an order of 16/3/24, page number 26.
Page,
Against the interim order,
where is the order?
page number 26.
Yes. You are the wife, husband?
Where
Husband,
I'm the husband.
yes.
Court allow me to pay rupees 3,500 at pendant light against my husband, to my wife in a case of Met 341, which is pending in additional decision number 2 in Nagaon.
Yes, what is wrong?
My lord, this respondent is my wife. She blame me, I am an impotent.
Huh?
She blame me, there's a rumor that I am an impotent. But she did not consume my conjugal life with me till the date of my marriage to till death by maternal health. But I am not an impotent. Medical report is there, summary, and she's created mental torture to me. She filed after.
What does she do? What does your wife do?
She's working in a private hospital. And
And how much do you earn?
I have only 44,000. I'm working with my garden's hardware shop.
Huh?
I am working in the hardware shop in my husband, my brother-in-law. But nothing is that. But the domestic violence case under protection, section 12 of the Protection Act, where she was examined and her mother was also examined. See, page 68, the cross examination is there.
Hmm.
She strictly may I allow to read.
How does this have relevance?
Yes.
How does this have relevance to that maintenance of 3,000 rupees given to you?
She created a mental torture. She did not consume the conjugal life with me.
Uh,
She's a mental torture to me, and she blamed me that I am important person. I am not the important person. This was already medical report is there in page number 73.
so if there is a cruelty by the wife,
Yes, this was cruelty by the wife,
understood?
not me.
If there is a case of cruelty by the wife, then there is no requirement of maintenance.
Maintenance.
Who says? You show me.
Mental cruelty, depend mind
Show
the-
me. Now let us assume that physical, mental, all cruelty is there by the wife upon you. Show me that the question of maintenance is not to be
we
given.
are not consumed till the date of
Madam,
marriage to
I
be- Yeah, yeah.
understand everything. You have not gone for a divorce, or who has gone for a divorce? Show me any law by which it says that if there is a cruelty by the wife which is yet to be proved, then there is no requirement of paying maintenance. Show me that. Only that, nothing more than.
I did not bring the citation, but I have been there. The Sanjay Kumar versus party respondent.
Where?
Full of international denial of sexual relations by the spouse amount to the mental quality. A normal and healthy sexual relationship is of the basic ingredient of the happy and the harmonious marriage. If anyone spouse willingly or intentionally denies sexual relationship in amount to be mental quality. And and Bundo versus
No,
Srimati
madam,
Marul,
madam,
Allahabad
I
High
hope
Court.
I am able to make you understand.
Yes.
You just show me that if you allege cruelty against your wife, she is not entitled to maintenance. Show me that.
In Bundo cases, this was already Allahabad High Court. This found that if the mere ground that the husband was important was not a just cause for the refusal of the wife to live with her husband, and accordingly dismissed the application filed by the respondent for maintenance.
Where? Which case?
Bundo versus Srimati Mahrul, Allahabad High Court. Site. You.
Where is your affidavit of assets? Where's your affidavit of assets?
Or did not submit it here. DPK's.
Huh?
In DPK's already filed it.
Where is it here?
Copy is not there.
How can this court decide that you don't have money? I don't see anything wrong with this order.
My lord, I am not consuming till
So what?
till date.
She's your wife. You get a divorce.
She's completely rumor.
Get a divorce and get her out of your life. That is another aspect. I'm not concerned. I'm only concerned as to whether in terms of section 24, she is entitled to maintain it.
She's completely plain with me. So she married me. She has another boyfriend before prior to marriage. She has
Have
a
you
boyfriend
proved it?
only for.
Madam, have you proved it?
No, she was already admitted in her.
That she has a boyfriend?
evidence in DB case. Not it's admitted.
Then
Just
don't
remain.
come up. And I'm not concerned with the DV case out here. I'm concerned with this case.
Yes, my lord.
There's
But you may
nothing
go
wrong.
to this evidence of the respondent in page number 68.
We'll have it on some other day. Not going to stay anything of this. We'll have it on 29. File your affidavit of asset. Affidavit. From the materials on record, it does not transpire that the plaintiff, the petitioner herein, has filed the affidavit of assets. In fact, it is also seen in the order passed by the learned order impugned that the affidavit of assets was also not filed. By the husband, by the petitioner. Taking into account this, let this matter be again listed on 29th of May 2024. In the meantime, the petitioner is given the liberty to file the affidavit of assets and liabilities.
Highly obliged.
Right with the doctor. In this case, the respondent executed an agreement for sale with the petitioner on 4/8/2022, wherein amount of 14,25,000 was fixed as consideration amount. Accordingly, your lordship, the petitioner has in the meantime paid about 14 lakhs. The possession was also given to him, your lordship. And he developed the land by art filling and also done
You are the plaintiff?
plaintiff.
What is your suit for?
Suit for a specific performance of contract. There was an injunction order, your lordship. He vehemently violated the injunction order, carried out the construction work in the suit land.
You are asking for specific performance.
Specific
Your agreement is with whom? The defendant, number one.
Yes, sir.
Who is the defendant, number two?
He is a pro forma defendant. The other side of the land belongs to that defendant number 2.
Why you are making him a party?
Because he has the defendant number 1 has entered into an agreement to sale to purchase another portion of the land from the defendant number 2. So what happened when giving the boundary of the land? On one side, I have said that it is the land of the petitioner, defendant number 1, because he has already entered into an agreement of sale with the defendant number 2. So he was made a pro forma defendant in the case. But
In
basically,
respect to the same land,
same.
the defendant number
portion of the
1
land.
entered into an agreement with the defendant number 2.
No, you're confused. Suppose there are 4 cutters of land. 2 cutters belong to the defendant number 1. 2 cutters belong to defendant number 2. Both of them purchased together. So what happened thereafter? Defendant number 1 entered into an agreement to say to defendant number 2, means he wanted to purchase the 2 cutters of the defendant number 2. Now I have entered into agreement with the defendant number 1 in respect of his 2 cutters of land. In that schedule, I have given the boundaries, showing him that defendant number 1 is also the owner of the adjacent land, which in fact is the land of the defendant number 2.
Okay, now what has happened?
Now, your lordship, I was given the position. I have started construction work. I have also done the work up to the 15th level. And thereafter, what happened when I asked him to execute the contract, to take the permission and execute the final sale date, instead of doing that, he started developing my land over the suit land.
How?
Up to the lordship will see at annexure 1, page 14. That was the work that I have done. I have given the photograph. Dates are also there. So I have done the art filling work, and then up to the 15th level, I have completed because I was given the position. But thereafter, when I said that please execute the sale, he denied. Thereafter, I filed this title, seeking.
You had an agreement, registered agreement?
It is not a registered agreement.
Then what right do you have to construct?
Because he has already given the
So what?
position also, your lordship.
He may do many things, but in the court of law, what right do you have to construct? Wouldn't that be a would it come within the ambit of section 17(1)(a)? No. Some rights have to be there
Yeah.
to claim benefit under 53(a). What is your right? Without an unregistered document. Your only right, if we see from section 54, is a right to get the deed of sale executed in your favor. So,
That is what I have filed the title suit for.
Yeah.
Now, during,
now what injunction did you seek for?
I got an injunction that he should not change the nature and feature of the land.
Then you must have got some injunction.
I have got an injunction in my court
For what?
that he should not carry out any construction work over the suit land.
Then,
Then he, even what happened, he did not participate in this injunction process. Even though the learned court below has asked him, he has appeared,
who filed an appeal?
he filed an appeal.
And what is the order passed?
Appeal is dismissed, but the order has been modified to the extent that status quo as on date to be maintained.
Very well. What is wrong?
After filing of the injunction order until the status quo order is passed, in between he has developed and he has taken over the possession of the whole land a lot. He's enjoying the
So
land.
you want to take over the position now?
I want that when the injunction order was passed, that it be remained on that position only a lot.
So he says status quo as on today. What does the order pass?
Yes, a lot. The first injunction order that was passed, a lot of people get it on page 54 by the trial court.
Accordingly, partially modifying the both parties are directed to maintain status quo over the land till the disposal of it. So the status quo has to be on the date of the order. So what is wrong?
Your Lordship, when the injunction order was passed at page number 52, there was a specific direction that we should not change the nature and feature of the land. It was
So
on
now he cannot.
on 27/9/2023, Your Lordship, the order was passed. He was well aware of the order. I have filed a violation case also. Now, because of the status quo order, this violation case will also become infructuous.
Why?
Because the learned appellate court has now asked that the status quo should be maintained. Even after the injunction order was there,
The status quo mean the same. Wouldn't it mean when the court says as regard status quo over the suit land means that the possession will remain the same. The what do you call the nature and character cannot be changed, as well as also to the effect that what do you call the title will remain the same. So
on 27/9/2023, when the injunction order was passed, there was no construction. In fact, some construction was there, but after that injunction order, he has completed the whole building.
now there is a direction to maintain status quo. It means what is there? The property cannot be either sold or changed or done anything with.
Once the appeal is dismissed on contest, Your Lordship, how this modification can come, Your Lordship? It is the view of the learned appellate court that the appeal is dismissed on contest. But then he has modified the whole order, Your Lordship. Once this order is modified, now status quo means he is now enjoy the land. He has taken over the whole land. He has.
So, do you want the land back to you?
I
For that, don't you have to file a suit for recovery?
that is there, Your Lordship.
Or suit for, in your suit, don't you have to now amend it? By saying that in the meantime, I have been dispossessed, so now I need a possession.
Sorry, but that is the
If you don't ask for to, you'll be hit under 21 of the specific. Then how does it affect anything with the status quo?
by violating the court order, he has done it, Your Lordship. Now he will enjoy because of this status quo order, Your Lordship. Let the property remain not in possession of either party. Now he has started shop. He is doing business over the.
Or you want to turn the civil court into a proceeding under 145, 146?
That is not there, but there are orders of this order of the land trial court granting injunction. Even after granting of injunction,
Status quo is also an injunction.
so by that time, when the
You want both parties should not do anything in
yes,
respect to it.
yes,
Isn't that the meaning of status quo?
because of the status quo, he has already started talks about that their construction completed, talks about that he is now doing business in the status quo order will not have any effect on.
He is
him.
now carrying on business.
Yes, I have annexed the photograph. Yes,
So isn't that a case of violation?
violation. I have filed a violation case, but because of the status quo order, and if status quo order will remain in court, court will not go for violation because there is an
But
order
the
of,
status quo order came later on only.
yes, yes.
So the violation must have happened prior to that.
Prior to that, I have filed
So how
violation.
does it will affect it?
Now today there will be no violation because of the status quo order, he is now enjoying the land. Now, how the law?
He will enjoy now, but he has already violated. What has been violated can always be taken over. You see, the problem arises in that you have been in the meantime dispossessed. So if you are being dispossessed from the land, you need to get the possession back. You have to move certain application.
That I will do, your lordship, but
If you don't do that, how does it have any relevance? As of now, your right is only for the purpose that he should not sell the land. That's it. The best injunction you can get, not to create third-party rights.
person who has blatantly violated the court's order, and after that he has carried out the construction work, and when the appeal was filed, no such ground was taken, and the appeal was dismissed on contest, but the order was modified, your lord. Even the police has also informed him that he could not carry out the construction work. After filing of the violation case, the court asked for the police report inquiry. During inquiry, the police said that I visited the place and found him doing the construction work. I submitted him a copy and said that not to carry out the construction work. But thereafter, he has carried out the construction work. He had started stopped over there and enjoying the land, your lord. Because of the status quo order, now he will enjoy the land like any. So injunction order, when it was passed on 27/9/2020, that status quo as on that date be maintained, your lord.
You want a status quo ante now? Without any application filed for mandatory injunction?
So that they will file in the planet court. File in the law court.
So, what actually you want is a status quo ante. In an appeal arising in a 227 application
I am
arising
confused by the order.
against
When
the
the appeal is dismissed on contest, how the appeal can be then order can be modified? They are finding lot people that at page number 80.
no, whether this injunction remains. As of now, once it has been modified, you will go for violation.
Now how it will be violated because of the modification.
Understood. Once it is this order, I deem it fit and proper to pass an order restraining so and so from changing the nature and character of the suit property. According so and so, are restrained from changing the nature and character of the suit property. This is the injunction which was passed at page 61. So then, the order is only not to change the nature and character, not as regards the possession.
Nature and character at that time construction was not there.
So you want to break those? Break it. Ask the court to break it. File an application.
Once the order has been modified.
The order which has been passed out here, the status quo has to be understood in this regard. In fact, whatever he says out there, he categorically says OP in his main relations are restrained from changing the nature and character of the suit property. This order at page 61 arises when? By the trial court?
By the trial.
Why will the OP be restrained from changing the nature and character of the suit property when the possession is with you?
At that time also, your lordship, I have said that he is trying to put.
The trial court did not grant an injunction order to you to that effect, not to dispossess you.
By that time, he has already taken over the position.
So as on at page 61, the order which was passed was at the time when the possession has already been taken
Yes.
over.
Only after filing of the taking over of the possession, your lordship, I filed the mistake.
So therefore, only to not to change the nature and character.
Character.
So that remains the same nature and character.
Already he has changed the character of the land by developing the whole building, your lordship. Now the violation case will be of no use because the interim order, injunction order that was passed, that has been modified by the learned appellate court with us. Let us go.
No, it does not. You want to make it same, I will clarify it. That it is not, it is the same. Nothing which has been done. The
Learned appellate court below.
appellate court categorically says.
The appeal is dismissed on contest, but he has modified the order. Now he said that there should be a commissioner who will go to the court and then he will file a report.
Yes,
Learned
to
appellate
maintain it. What is wrong with this order? And why should I exercise 227 against?
I'm not on, I am section 115, your lordship.
Oh, then on that again, are you sure? 115? You're sure? You don't want 227?
227 is always,
No, 227 is not there. I'm asking you, you are under 115. I'm asking you, sure? 115. Okay. Hello. All right, Mr.
damage, your lordship.
And so the M. Hussain, the learned counsel appearing on behalf of the petitioner.
Damage, your lordship.
Good stuff. This is an appeal. This is an application. Under section 115 of the Code of Civil Procedure 1908, challenging the order dated 28/3/2024, passed in Miss Appeal number 01/2024 by the Court of the District Judge Kachar Silchar. This court had persistently asked the learned counsel appearing on behalf of the petition as to whether this application is an application under section 115 of the Code of Civil Procedure 1908 or is an application under Article 227 of the Constitution taking into account that there may have been some mistake. The learned counsel categorically submits that this is an application under 115 of the Code of Civil Procedure 1908. Taking into account the said, this court having taken note of the second proviso to section 115 of the Code of Civil Procedure 1908, as well as the judgment of the Supreme Court in the case of Surya Devi versus
Lordship, if it is there, then it may be converted under.
Huh?
But it may be converted.
No. You have asked it twice.
No, because I have filed it under 115, your lordship.
You have
That's
filed
correct.
it, that is wrong. And
Now, if there is,
sorry,
it can be converted, your lordship.
no, I'm not going to convert. I made it very
To prejudice the petition.
no peculiar circumstance. Internet नहीं कोई? Surya Dev Rai versus Ramchandar Rai, reported in 2003, 6 SCC 675. The instant petition is not maintained. This court further also have taken note of the order being passed by the learned First Appellate Court, from where this court finds no reasons also to interfere with the same. Accordingly, the instant petition is dismissed as being not maintainable as well as also on merits.
Not maintainable, that part may be a lot.
Absolutely no.
No, because. your
No,
lordship,
sorry.
when,
You
uh,
may.
we
I
moved
asked
the
you
we
twice.
moved the registry also, your lordship.
What?
When the registry has also,
Registry? You file it under 115. Is the registry supposed to know all these things? You have been in practice for how long? Then also you should be knowing. This is the fundamental. You can't file a 227, 115 against an injunction order. Next.
it comes with, sometimes your lordship, earlier we have filed under 115 years.
Fantastic. Go to that court then. Next time.
Oblige.
Yes, what is this?
Is that matter it was an application?
Yes, That day I gave a judgment on requisition. And not only that, I have also the yes, 2 days before there is a judgment of the Supreme Court. Kolkata Municipal Corporation versus Bimal Kumar. Yes, you have got everything. Now, when you are doing the acquisition, Patta you have got?
Yes, sir.
Patta we have issued, my lord.
Okay.
Lordship will find a patta there, as well as, my lord, the record of rights, that is the Jamabondi, my lord, and also the trace map. In fact, my lord, the Jamabondi trace map and Sitha, all these are placed before this honorable court of an earlier occasion. Nonetheless, my lord, these are placed again. Only issue was that, my lord, Lordship has directed the authorities to hand over a patta, formal patta. That has been handed over, my lord. They have got it.
Now tell
No.
me, when are you acquiring it?
Lordship will kindly accommodate us at least for 4 weeks, my lord. Let me communicate, my lord, to the authorities for acquisition, because there is a move, my lord, from the government that in all these kind of pending matters, my lord, where acquisition process, rightly or wrongly, are being stalled, those matters are to be, my lord, revived again, and in a speedy manner, my lord, it has to be acquired.
Now you will be acquiring as per the new act,
Anyway,
2013.
2013, my lord, we will be acquiring under the 1964 Act, but my lord, the compensation formula as, my lord, deduced in 2013.
1964 Act, if they acquire, just file a petition, another writ before this. We'll take it up because 1964 Act, in view of the recent judgment of the Supreme Court that Kolkata is wrong, because now they don't have, unless they categorically say, you see, 1964 Act, there is a big problem. And this is made very clear that when the Act, what happens? The Act initiates with Section 6, and on the basis, it is taken over. You don't have a right to oppose, to be heard. That is not permissible. That is a violation to 300A. I'll give you that. And on the basis of that, because you cannot do this unless 64 Act categorically says that we are going to follow the principles which are there in either the 13 Act or the 1894 Act. Because 1894 Act gives certain benefits. If they want to do it, what they are doing under the state of Assam is doing, they are exercising 64, not resorting to 17, which is there under the 1894 Act or under this Act, the urgency provision. And if it is an urgency provision, they have to pay the 80%. They are not doing it. Take this. I was all along thinking how to do this with this 64 Act, the government, and now recently the Supreme Court has come up with this beautiful judgment. Kolkata Municipal Corporation and another, Bimal Kumar Shah and others, 2024 INSC 435. This is a judgment by Justice Narasimha on 16th of May 2020. Here, one thing very nice about this judgment is, what does it say? A very beautiful judgment on this aspect. Says, right under Article 300A includes the right of notice, a right to be heard, which is not there in Section 6, right to a reasoned decision, which means he has to intimate you, nothing is done, duty to acquire only for public purpose, that may be there for now, right of restitution or fair compensation, which they have to do it, a right to an efficient and expeditious process, which they have not done, and right to a conclusion by which your rights stands vested up. And the Supreme Court says that any of these 7 rights is either one or some of them are violated. It's a violation to 304A and accordingly is in violation to
No, my lord, the state government has formulated a rules in 2015. That is under the
Forget about those rules. Those rules have no business out there. The rules which you are saying about that Act of 2014,
30.
2013, about that Act. But you don't follow that Act, na?
We do not follow the procedure. At the end of the day, the quantum
You see,
of money.
you can very well say, okay, we don't follow the procedure as regards the social impact assessment. Very well, you can take that because that is a long aspect which may have difficulties. But can you say that you don't follow even the right to be heard by them, which is all there? You see, 1894, the Supreme Court in this judgment categorically says that 1894 Act categorically says many aspects. One is that Section 4, then hearing under 5A. Now this 5A hearing can be dispensed with only in exceptional circumstances. And then 17.4, 80% compensation is to be given. 5A, which they don't do it. Absolutely. They take away all this. Then they come up with 6. 6, then you have 8. 8 is a right of hearing, 9 is a right of hearing. They have construed 9 to be the information given to you that kindly come and take the money. 9 is not there. 9 is asking them, okay, now we are going to take it. Because 6 says I am going to take it. 9 says, okay, we are taking it. What do you have to say about the compensation? This is a right to be heard on the compensation. Nothing. They don't do it. They all do it by themselves. Then comes, after hearing, you come to 10 and 11. 11 is the award. And then the payment is to be made as per 30. They have construed 30 to be 9. This is what is happening. And for them, we have all the powers in the world in view of 64. So you do.
I will communicate, Lordship will accommodate me for 4 weeks, my lord.
For what?
To initiate proceedings, my lord, appropriate proceedings. Now, since my lord, it is under requisition, prolonged requisition.
Acquisition?
No, requisition.
Why?
No, Lord.
Why do you want to requisition now?
So therefore, since the land, part and parcel of
Now
land,
you want to break the building?
no, my
More?
lord, no, we will be acquiring it.
No, then why you are going for requisition?
Not requisition. I am not spelling out requisition.
No, requisition.
My supposition is that, my lord, till now, because since at one point of time it was requisition, it was never acquisition, admitted fact. Now there is a Supreme Court decision which Lordship is also pointed out. I have also gone through it. There cannot be any prolonged requisition. Fact remains, my lord, that those part and parcel of land are still in the stage of requisition. So that will go. Now the authorities will have to initiate fresh acquisition proceedings under the 2013 Act.
Because the moment you start it, then he gets rights to get the money.
Definitely.
His interest starts to calculate.
Definitely.
When you are going to do?
That, my lord, I will communicate.
As of now, you are in illegal possession.
So we have already communicated.
As of now, this land is not under requisition.
They are under because that law, this honorable court has not interfered till now. So that is the reason Lordship has kept this matter pending and asking the authorities because in the meantime there were some irregularities.
No, you can't go for requisition or all these basis.
Not acquisition, my lord. We are
Because
going
that-
for state acquisition.
In this judgment, you also see this judgment of B.S. Chasdeva. There is a judgment of Justice Ravindra Bhatt. It says that these type of actions are to be caught hold of by the court, and if the court does not do it, it would be the court not exercising its powers where it should. You see a recent judgment I've delivered where he is a party, where he was one of the counsels. That is pertaining to some judgment recently I've given. So there you see it. You see, the judgment, requisition judgments first started with H.D. Vora. The matter went to the Supreme Court, Constitution bench. They did not interfere. However, they say as to whether for a permanent or not, it has to be, we have to take note of. We'll keep the question open. Thereafter, in 97, the Supreme Court said that if they want to go for a requisition, and if the land ought to have been acquired, then have to furnish reason why for this small period of time they want it for requisition. Otherwise, it is bad. And this is further supplemented by the 2023 judgment. Eh? Manu?
Modified, simplified, purpose, and another.
No. Some such deva. Be a such deva. Yes, this is a very important case which needs to be taken note of. And B.K. Ravichandra, 2021-14 SEC 703. Here the Supreme Court says, to that extent, in paragraph number 21, the legal effect of requisitioning immovable property, it goes without saying, is that temporarily, that is for a period, the requisition order is in operation, the owner loses her right, so and so, not this one, not this paragraph. Yes. The phrasing of Article 300A is determinative and its resemblance with Article 21 and 265 cannot be overlooked. They are in effect the guarantees of supremacy of the rule of law, no less. To permit the state, whether the union or the state government, to assert that it has an indefinite or overriding right to continue occupy one's property, bereft of lawful sanction, whatever be the pretext, it is no less than condoning lawlessness. The court's role is to act as a guarantor and a zealous protector of the people's liberty, be they assured through the freedom and the right of equality and religion or cultural rights under Part 3 of the Constitution, or the right against deprivation in any form through any process other than law. Any condonation by the court is a validation of such unlawful executive behavior, which it then can justify its conduct on the anvil of some loftier purpose at any future time, aptly described as a loaded weapon ready for the hand of an authority that can bring forward a plausible claim of an urgent need. So this is, anyways, how much?
Lordship, what I would respectfully ask, Lordship may kindly, my Lord, pass a picture indicating the law laid down by the apex court, so that I can persuade the authorities.
For what?
My Lord, to go for acquisition, my Lord.
No, they want the valuable land. Now they have got the patta.
They have got the patta.
So now they are more happy with the valuable land. It's in the midst of the town. If you don't do it, you lose it out. Isn't it? I'll record their submission that they want the land back now that they have got the patta. Now you say that you want to acquire. So sometime 4 weeks is given as to what update can.
In fact, I had been communicating to the authorities, but in the meantime, my Lord, since these developments have occurred, now the government is taking a conscious decision, my Lord. There are not only these solitary matters, my Lord, there are some other matters.
I'm not concerned with others, I'm limited to it.
More
Mr. A.
particularly, my Lord,
Sandil, the
arising out
learned
of-
counsel appearing on behalf of the petition, submits that pursuant to orders passed by this court, the patta have been duly issued in favor of the petitioner and they have been also given the copy of, have been also issued the patta. He further submits that the land in question is a very valuable land, and the state, in the evil of some loftier purpose, cannot keep these lands under their control, under their right, under their possession and control, without exercising the rights, without which would otherwise be in violation of the provisions of Article 300A of the Constitution. The Learned Counsel referred to a recent judgment of the Supreme Court in the case of Kolkata Municipal Authority, Kolkata Municipal Corporation and another versus Bimal Kumar Shah and others, delivered on 16th of May 2024, reported in 2024 INSC 435, wherein the Supreme Court categorically mandated that there are 7 postulates of the freedom of the rights under Article 300A of the Constitution. Mr. Sandilla further submitted that these 7 postulates constitute the right to notice, the right to be heard, right to a reasoned decision, the duty upon the respondents to acquire only for public purpose, the right of restitution or fair compensation, the right to an efficient and expeditious process, and the right to a conclusion. He therefore submits that keeping this that for all these years, the respondent authorities have kept these lands under their possession and control, which could not have been done, as it is explicitly in violation to the well-settled law laid down by the Supreme Court, but in the case of H.D. Vora versus, yes, what is that?
But the one minority given at 2021-14.
Oh,
No, everywhere is something different.
H.D. Vora.
That is the minority title.
Mr. Kandila, when you are doing a matter, you have to be ready. H.D. Vora versus State of Maharashtra and others, reported in 1984 2 SCC 337. He submits that the respondent authorities may be directed to immediately vacate the handover, the possession of the land to the petition. On the other hand, Mr. R. Pujari submits that the acquisition of the land in question is under active consideration of the government, and as such, further to that, at this stage, to take any action of handing over would be disastrous to the public interest, taking into account that there is already permanent structures which are being used for the purpose of the Guwahati Medical
and
College.
hospital.
He therefore submits to give an update before this court as regards the stage of acquisition process, and in that regard seeks for an accommodation of 4 weeks. This court directs the listing of this matter again on 24th of June, on which state, taking into account the progress made by the state in taking steps for acquisition of the land in question, this court would further consider the submissions of the Learned Counsel for the petition.
I'm obliged.
Okay.
Yes.
Due to subsequent development, my lord, the petition has become instructive. Due to subsequent development, because thereafter again the plaintiff was amended. And it is proceeded for.
What are you challenging this order? Order 39, 1 and 2.
Petition, my lord. If order is at 104, my lord.
Injunction has been denied. Then what happened?
Injunction given interim order passed here, but my lord, still they have taken possession again, my lord. Earlier it was vacated. Again, they have taken possession in my lord.
There is no
Second
injunction order here.
Yes, my.
He is a great person who have granted injunction. In view of the till the next day, operation of the impugned order is stayed on, restoring the order dated demand till the next returnable debt. What is
They are in
12,
possession
12.5? 12.5, there was an injunction order.
Injunction order. But
Well,
my lord,
Indeed, that order
again,
is
they
not annexed.
forcibly- they
That,
forcibly
that
again
order is
taken
not
possession.
here.
Not here, Lord.
Honorable Justice speak it again.
Then,
That
now, what
I
is the
will
stage of the
explain.
suit?
My lord, it is in my lord, last is my lord, the honorable court has ordered my lord only one day witness, I think, today witness, their witnesses are not coming. So it is in a cross examination stage, my lord, and my lord, honorable court has ordered that by 38th May, it has to be finished, he will take the first paper.
Okay. Now, what is happening?
Lordship.
What is
Last-
happening as
Last
regards
day,
this
petition
injunction?
again,
Injunction was
what
only
happened?
till the
Lordship.
next date.
The injunction, initial injunction order was passed existing that is restraining the defendant
Hmm.
from disturbing the possession of the plaintiff because that the suit was for declaration of right and interest, confirmation of possession. Injunction order was there. So in the meanwhile, they filed the application that she has been disposed. So there is a recovery possession has been sought.
So nothing remains here.
Nothing remains.
nothing.
Yeah. This is an appeal under Order 43, Rule 1R, challenging the order dated 30/8/2011, passed in Mise case number 82/2011, arising out of title suit number 1133/2011, wherein the learned trial court rejected the injunction application filed by the plaintiff, who is the appellant herein. Full stop. It is relevant to take note of that the injunction application was for recovery of possession, was
recovery
not
of-
to disturb the possession of the plaintiff over the suit land.
Lordship.
Injunction was given, then it is vacated.
Your injunction application was not to disturb the possession of the plaintiff
Entering the
from the
premise.
suit land.
Yes.
Full stop.
Entering the premise.
However, in the meantime, it has been brought to the attention of this court that the plaintiff had filed an application, have already amended the plaint seeking recovery of possession. Taking into account the above, therefore, the entire injunction proceedings, including the instant appeal, has become redundant, for which the instant appeal stands closed. Interim orders, if any, stand vacated. It's closed.
Obliged.
Itu diberi Mrs. Nirupama Soikya, appellant in person. Yes.
So, the petitioners have filed in title suit. An order was passed in by motion number 1 on 29/7/2016.
Where is that order?
Order is that annexer 1, page number 8.
What is that order for? Section 6.
Yes.
What happened? To dismiss allowed what? What? What is this type of order? Annexer? Vicky. Which order you are challenging?
Lordship, we have come before you, challenging the answer 47, last page, your Lordship.
Huh?
The order
18/2/2020, my lord.
Case record is put up. One picture on the same praying that this court to direct the district court is subordinate to partition the suit property by meets and bounds by Peru, where the Peru of the document and what is the decree for?
right title and possession was
A
allowed in
decree declaring right title and interest and possession of the plaintiff over the suit land along with the defendant. A decree for partition of Iman, the plaintiff heir has inherited 1/8 of the property and the remaining 7/8 has been inherited by his son and daughter in the ratio. Son has got 2/3 of the Iman. Decree for permanent injunction. Decree for making good. Now, there is no direction to the collector.
no, nothing has been done. Order was passed on 29/7.
And what does the first appellate court do?
It upheld the order of the municipal court. It upheld, the appeal was dismissed and the order of the municipal was upheld. And
Mhm.
subsequently, we approached the municipal court for preparation of the decree, and it was rejected by this order 18/2/2020. So that's why we are before your lordship.
You file it in the suit. In fact, there should have been a direction.
There should have been a direction, my lord, but even if, my lord, they are going to file the execution proceeding, because it is a composite decree. And at page number 27, your lordship will be pleased to find that the shares are already determined. So if they are going to file this execution proceeding, there is nothing like, because she is my mother and the sister. She will be getting 1/8 of the share. I will be getting 2/3. My sister will be getting 1/3. My
No, isn't it the duty of the collector to do those? This will be a decree under Order 20, Rule 18, 1.
yes, my lord. Yes.
So, isn't that the duty of the court to direct it?
So if the execution proceeding is filed, my lord, certainly there will be direction, my lord, for
For
execution
the
of the
municipal court for giving directions, and same was dismissed. That's why you are before your lordship.
Now, there being no decree passed by the learned trial court, how can the executive court direct? To give effect to it, can
to it.
it
Under
has.
section 54.
We
my
do
lord.
one thing. We don't do anything with this order. In fact, we give you the liberty to file an application for execution, and the executing court shall direct under section 54 to the collector to do.
Full purpose.
I think that will be proper. But you have to file an. This is an application under Article 227 of the Constitution challenging the order dated 18/2/2020, passed in title suit number 157/2013, whereby the application filed under Section 54 of the Code of Civil Procedure 1908 was rejected. This court have duly taken note of that the appellant herein, the petitioner herein, had filed a suit. Petitioners, had filed a suit which was registered and numbered as title suit number 157/2013. The said suit was filed seeking a decree declaring right, title, and interest and possession of the plaintiffs over the suit land, along with the defendant number 1, semicolon, a preliminary decree for partition of the suit land amongst the plaintiffs and the defendant number 1 as per the Sunni sect of Muslim law as follows, as under Roman 1, share portion of the plaintiff number 1 in the suit property dash 2.5 lesser, 2.5 lesser. Number 2, share portion of the plaintiff number 2 in the suit property dash 8.75 lectures. Number 3, share portion of the defendant number 1 in the suit property dash 8.57 lectures. Number C, a decree for file the said suit seeking the following prayers, which is given herein under page 11 of the plaintiff prayer. The learned trial court, by the judgment and decree, decreed the suit in favor of the plaintiff by the judgment dated 29/7/2016. Paragraph number 21 of the said judgment is reproduced herein under page 27 of. Being aggrieved, an appeal was prepared by the defendant number 1, who is the respondent in the instant proceedings. The said appeal was registered and numbered as title appeal number 107/2016. The said appeal was dismissed by judgment and decree dated
12/7/2019.
12/7/2019, whereby the judgment and decree passed by the learned trial court dated
29/7/2016, my lord.
have been affirmed. 29/7/2016 in title suit number 157/2013 was affirmed. Pursuant thereto, the petitioners herein filed an application under section 54 of the Code of Civil Procedure 1908 before the learned trial court. The said application was filed in title suit number 157/2013. In terms of the relief which have been sought for in the said application, a direction was sought for directing the district collector of the Kamrup Metro or his gazetted subordinate to partition the suit land property by metes and bounds and to submit report, and thereupon to prepare a final decree by allotting the shares to the plaintiff on receiving the report from the district collector of the Kamrup Metro district or any of his gazette subordinates. This application was rejected by the order dated 18/2/2020, and as such, the present proceedings. I've heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner, and Mr. A. Sattar, the learned counsel, appearing on behalf of the respondent. From a perusal of the judgment and decree passed by the learned trial court dated 29/7/2016, it reveals that the said judgment is a judgment rendered in terms with Order 20, Rule 18(1) of the Code of Civil Procedure 1908, whereby the shares of the parties have been duly decided by the learned trial court. Under such circumstances, it is therefore the requirement in terms of Section 54 for the revenue authorities, that is the Deputy Commissioner, Kamrup Metro, or any officer subordinate to him, to effect the partition in accordance with the judgment and decree dated 29/7/2016, passed in title suit number so and so. In fact, the judgment and decree passed by the learned trial court ought to have contained this direction. Be that as it may, this court finds it very pertinent to observe that Section 47 of the Code of Civil Procedure 1908 duly confers jurisdiction upon the learned executing court to decide all questions relating to execution, discharge, or satisfaction of the decree. And as such, in the opinion of this court, the petitioner ought to have filed an application for execution of the decree dated 29/7/2016. And in such an as and when such application would have been filed, the executing court, in exercise of the powers under Section 47, could have directed the revenue authorities in terms with Section 54 of the Code of Civil Procedure to effect partition in terms with the decree. The learned counsel appearing on behalf of the petitioner submits that the petitioner shall now take appropriate steps in that regard. Taking into account the above, this court disposes of the instant petition, thereby granting liberty to the petitioners herein to file an application for execution of the judgment and decree dated 29/7/2016, passed in title suit number 153/2000.
157/2013, my.
2013. Upon such an application being filed, along with such other application as to advise, the learned executing court shall pass appropriate orders in terms with the observations made herein above.
Obliged.
With above the instant petitions. You file with that execution, that another application. Yes, what is this?
Appellant was the dependent party.
Hmm?
Appellant is the dependent party. Ex parte judgment was passed. If notice but did not appear.
Then
Ex parte judgment was passed. Thereafter, first appeal was filed. That was also the exhibit one on which the suit was decreed. As per trial court and the first appeal court, it is a contingent contract. It is a contingent contract.
it's a suit for specific performance.
Yes, sir.
Suit specific performance for what?
For sale.
Why you are bringing mortgage deed?
Our case is that it is not a agreement for sale. This is a mortgage. There is a clause that if I do not pay the amount within 1 year, then I will sell the suit. So our contention was that it is not a contingent contract as had by both the courts, as because it's a mortgage. Section 31 of contract.
But there is no defense. So under such, how do we take that? We are to therefore decide on the basis of what the materials are otherwise are there. There is no foundation of these.
But Lordship, when there is no defense from the other side, it is the duty of the court to see the plaintiff's case first.
No.
And
The
trial
plaintiff,
case
the court, the duty of the court is only to see a prima facie case whether he has met out or not.
is the
Then-
court held that only PW1 was reduced, Lordship, no other evidence.
Not necessary. He has to give only prima facie evidence. Isn't
On
that?
that basis, only Lordship is good was.
Huh?
Section 31 of the contingent contract says, Lordship, a contingent contract is a contract to do or not to do something. If some event collateral to such contract does or does not happen.
Hmm.
The exhibit 1, as per exhibit 1, it is specifically stated that if I do not repay the amount within 1,
So you didn't pay. So then his right accrue.
our case is that Lordship,
Your case is you don't have a case. You have only a case if they don't have a case.
only that one, Lordship, and
That is the only case you have. That they don't have a case.
the only case here, Lordship, both the court said that the exhibit 1 itself a contingent contract, so PW1 to page 14 by the trial court. Para 5, the context of exhibit 1 proves that the agreement is a contract within the meaning of section 31 of the Indian Contract Act 1872, as the contract was based upon the event that if the defendant does not pay the earnest money of ₹7,000 only within 1 year from the execution of the agreement, then the defendant shall execute the exit in favor of the plaintiff. In respect of the suit, the execution of the exhibit 1 has been proved by the plaintiff, but only PW1. Further, the fact that the defendant has received ₹74,000 only as earnest money is revealed from the contents of exhibit 1 itself. Exhibit 2 and exhibit 3 are also proved by the PW1. Exhibit 2 is the office copy of the legal notice and exhibit 3 is the postal. The readiness and willingness on the part of the plaintiff to perform this part of contract is revealed from the contents of exhibit 2, and considering the fact and evidence available on record, I am of the considered opinion that plaintiff is entitled for the decision.
Yes, Mr. Mukherjee.
Lordship, before submitting anything on merit, I would submit that the registered sale deed is also executed in the execution case. In this case,
That they don't take.
Huh?
Possession is with us. Possession is not with the.
that is
Somebody was
because of an undertaking that I have given in this case on 3/6/22. By virtue of an undertaking that I would not proceed with the execution till the matter is decided on merits, the execution case is paid.
Then
Order dated 3/6/2020. Otherwise, the
Oh.
sale deed has been executed by the court. We have deposited the balance consideration. There is no
There is
pleading
a
on their part as such as well, Your Lordship, in this case. They've never,
But Mr. Mukherjee, tell me one thing. When on the you have for a super specific purpose. In a super specific performance, that agreement, was it an agreement for
agreement for sale.
mortgage by conditional sale?
It was an agreement for sale and
No, it was not an agreement for sale. Isn't it it was a conditional sale that in the circumstance, you don't make the payment within a period of 1 year, he would sell it to you.
no, Lord. Page number 27, Your Lordship, the judgment reflects. It translates the agreement. Page
Ah.
27.
27, yes.
Exhibit 1 states like this, that by this agreement for sale, I propose to sell my own share plot of land measuring 17 lessas due to need of money for my family expenses, and you being agreed to purchase the same at a total consideration of 1,20,000, and I took today an amount of 74,000 from you as an advance money. But be it mentioned herein that if I can return the advance money within 1 year, then you have to cancel the agreement for sale. And if otherwise I fail to return the money, I will execute the sale deed in your favor. So the point here is, in the event of repaying, the agreement has to be cancelled, Your Lordship. And it is a stated fact, it is an admitted fact, they did not repay the money. We sent a legal notice. They did not reply to that as well. Then we filed this case for specific performance. They did not turn up. And then rightly that 50 was passed.
have taken an agreement for there would have been clause that Lordship, the rest amount you will pay at the time of sale. That clause is not. As advance money, I have
Oh, it
taken
is not required now in view of section 55. What are the obligations of the vendors and the vendee? These are already there, isn't it? Even if you don't pay, you only have an interest over that portion of the money as per the fee. But these are questions. How can these be foundational facts without there is no foundation? How do you do it? That is a big problem. You directly file against an ex parte judgment without foundation. What do you do? If it was a case, it should have been remanded back. You could have made out a case for remanded to the other people. Different, but that is not being done. As of now, we can't do it. Okay.
some proper if I am not a party to it for a case, or if I find a review or order, then my question arises why you have not taken, why you have not filed appeal.
No, it's a different thing. You can very well say that in the appeal that you could have very well say that look here, the service was not properly done and as such, this I was under such circumstances. So finally, this is a fit case for remand. The court could have exercised the power because there was no evidence on the face. There was no evidence, no pleadings, nothing. Your stand was not there. But the fact that the court did not, I'm only under the 42.
So the not that I have not,
Huh?
I have not, it is not the key of the.
Well, these things I can't look into. Chalo, dekho. And this is an appeal under section 100 of the Code of Civil Procedure 1908. Challenging the judgment and decree dated 25/9/2019 entitled appeal number 10/2016, whereby the ex parte judgment and decree dated 24/2016 passed by the learned Munsir North Salmara Abhayapuri in title suit number 38/2015 was upheld. The instant appeal is being taken up at the stage of Order 41, Rule 11 of the court as to whether any substantial question of law can be formulated in terms with section 100 bracket 4 of the code. From a perusal of the substantial questions of law which have been proposed in the memo of appeal, it is seen that the first two substantial questions of law so proposed are in respect to as to whether the exhibit 1, which is the deed in question, was a mortgage deed or an agreement for sale. Inasmuch as if it was a case of a mortgage deed, it would be a case falling under section 58C, meaning thereby it was a mortgage with a conditional sale, or if it is an agreement for sale, the suit would be decided in terms with the provisions of the Specific Relief Act 1963. This court have duly taken note of that the learned first trial court as well as the first appellate court have duly, learned trial court as well as, and more particularly, first appellate court have duly taken note of the contents of the said exhibit 1. And on the basis thereof have categorically come to an opinion that it was an agreement for sale. This court have also taken note of the contents which is reflected in paragraph number 12 of the first appellate court judgment. And this court is also of the opinion that the learned first appellate court was justified in arriving at the conclusion that it was an agreement for sale. Under such circumstances, the first two substantial questions of law which have been proposed in the opinion of this court cannot be formulated as substantial questions of law involved in the appeal. The substantial question of law number 3 and 4 so proposed the substantial question of law number 3, in the opinion of this court, so proposed in the opinion of this court is totally misconceived, taking into account the well-settled proposition of law held in the case of, what is that judgment? That judgment was then page 2003 7 SCC 350, para 31. in the case of totally misconceived in view of the judgment of the Supreme Court in the case of Ramesh Chand Artavatia versus Anil Panjwani, reported in 2003-7 SEC 350, wherein the Supreme Court in paragraph number 31 paragraph number 33 categorically observed that in absence of denial of the plaint averment, the burden of proof on the plaintiff is not very heavy. A prima facie proof of the relevant facts constituting the cause of action would suffice, and the court would grant the plaintiff such relief as to which he may in law be found entitled. So, taking into account the above, this court above, and also perusing the judgments passed by the learned first trial court as well as the first appellate court, this court is of the opinion that the learned trial court have duly taken into account the requirements, required evidence, required materials, including the evidence, for the purpose of passing the ex parte judgment and decree in favor of the plaintiff. The fourth question of law so proposed as to whether the judgment and decree passed by both the courts of law are sustainable in law, in the opinion of this court, cannot be said to be a substantive question of law involved in the instant appeal. Accordingly, this court finds no merit in the instant appeal, for which the instant appeal stands dismissed with cost. How long you have got to stay? With cost quantified at rupees 11,000, taking into account that the instant appeal has been pending and the respondents have duly appeared in the matter. In addition to that, the appellant shall also be, the respondent shall also be entitled to cost of proceedings.
Okay, the stay order.
Stay order.
Okay.
My lord, this is the second appeal arising out of the judgment, my lord, dated 6/4/2023 and 24/3/2023. Title appeal number 29 of the judgment contrary to the pleading of the client. Contrary to
What is this case?
my lord, the plaintiff as well as the defendant, my lord, both are the sisters.
Hmm.
Daughter of Sahira Khatun, to whom, my lord, his husband has gifted 5 bigha of land. 5 bigha of land. Apart from having 18 bigha, 2 katta, 18 lakh of land, my lord. And the plaintiff has claimed, my lord, that the 1 bigha out of 2 bigha, my lord, belonging to her, and she is in continuous possession of the same. My lord, if I can take the lord, page number 34, that there, sir.
Who is Sahira Khatun?
Sahira Khatun is the mother of Jubeda Khatun and Yaj Khatun. Second wife of Mukim Khan.
Mother of the plaintiff.
Father of the
Sahira Khatun is the mother of.
Mother of the plaintiff and mother of the defendant also.
So you admit that the C schedule land, 1 bigha belongs to the defendant and the other bigha belongs to the plaintiff.
Right.
The defendant's case is this 1 bigha of land that is your case is, you are the defendant,
Right.
was donated to you by the plaintiff by a gift. That's your case.
Right.
He did not ask for a recovery of past possession,
No, my
but the trial court granted.
Right.
That's your substance. What is your basis to do that? When there is no issue also framed to that effect.
Yes, my lord, issues are at page number 50.
And that I've finished. There's no issue
That, no.
for recovery of possession.
That's why, my lord, for the result of the lordship, I have 1021. There are also many.
When the trial court held in page 55,
Yes,
last 3 lines, there's no evidence on record to show that the plaintiff was not in possession of the suitcase.
Yes.
If that finding is there, what was the necessity of delivering of khas possession? How does the appellate court take note of it?
Appellate court, my lord. That is 54, my lord, at page number 54, you wrote to see that discussion and decision on one. 65 is the judgment of the appellate court.
So the court exercised the powers under Order 7, Rule 7,
7, my lord, yes.
the first appellate.
Right.
Now, would this be a substantive
but-
question of law?
But that substantial question of law, my lord, I have framed at page number 11.
No, the question is whether it would the delivering of possession.
The relief which is not sought for.
Hmm?
The relief which is not sought for. Delivery of position. Because all along the plaintiff is claiming that he is in possession of that.
Heard Mr. A. Sattar, the learned counsel appearing on top of the appellate. Is an appeal under section 100 of procedure 1908 challenging the judgment. The 4th of March 2020 passed in title appeal number 29 of the 2018. Whereby the appeal filed by the appellate herein was dismissed, thereby upholding the decree passed, the judgment and decree dated 2/6/2018 passed by the learned Munsif number 1 Borbetta entitled suit number 03 of the 2016. The instant appeal is admitted by formulating the following questions of law. Whether the learned first appellate court, whether the learned courts below could have, in exercise of the powers under Order 7, Rule 7, of the Code of Civil Procedure 1908 grant the relief of delivery of recovery of possession when the plaintiff all along claimed that she was in possession of the Schedule 1 land. Whether the suit would have been maintainable in view of the provisos of Section 34 of the Specific Relief Act. If the plaintiff was not in possession of the Schedule C1, I think that is also required, because if he is not, then how does 64 come in? Huh? How does 64 come in?
Leave a second, regarding limitation, my
Huh?
But since the days of my mother, I was there, my lord, and she had given that.
So it will be a suit based on title.
This is good based on title.
No, it therefore 64, 65 only is applicable when it is for recovery of possession. How does therefore 64 or 65 come into the picture?
Leave was taken, my lord. Leave as a defendant was taken, my lord.
To that effect?
Yes.
That you are in possession
I am in.
and the suit is barred. But you have not claimed adverse possession.
No, no. But that cannot claim adverse position against the.
You should notice ऊपर देने के लिए that appeal is submitted only to the following substantial questions. You should notice steps be taken within 3 days upon responded by registered as executor to call for LCR. I acknowledge because this is an application what is order 21?
No, my
Did you
lord,
file order
ma-
41?
that is there, my lord, 25, IA number
2578 of
2578.
2020.
Yes.
This is an application under order 41 rule 5, the Code of Civil Procedure for stay of the judgment and plea dated 24/3/2023. Passed by the learned court of the civil judge Corpeta in title appeal number 29 of 2018. This court had already, in the accompanying appeal, had already admitted the accompanying appeal by formulating two substantial questions of law. This court have also taken note of that in the state suit, the plaintiff did not pray for recovery of possession. However, the learned trial court have granted the said relief, and prima facie it appears to be based on conjectures and surmises. It is also relevant to take note of that if the impugned judgment and decree dated 24/3/2013, passed in title appeal number 29/2018 is not stayed. It would result in causing irretrievable injury to the plaintiff, to the applicant. And as such, the impugned judgment and decree dated 24/3/2023, passed in title appeal number 29/18 is stayed till the disposal of the appeal. And what is this?
My lord, that was
631.
the mere information given because execution was going.
We
So-
close it.
No, my lord, that will be good. I don't
Mr.
think-
A. Satta, the learned counsel appearing on behalf of the applicant, submits that he would not like to press the instant application, taking into account that the accompanying appeal has already been admitted and the state impugned judgment and decree have already been stayed by us.
Right.
I accordingly states closed on.
Item 7.
But can it be taken up at two lots? Because Mr. P's account left in court number 14. Can it be taken up at two lots?
Why?
Mr. P's account left in court number 14.
First of all, who are you?
I'm for the respondent.
I don't hear the before. In an order 41 will you live?
Yes, sir.
Get it. You'll get a chance if I appeal, admit the appeal. And if I
This is-
dismiss it, ask Mr. P.T. Decker to be present to show his name in it.
It is the issue. Notice is the issue.
Notice,
Notice was issued.
Already issued.
And the LCA was also.
show me a provision under which in a proceedings of the order and section 100 notices it.
Because
LCR is,
I thought it would.
tell me what is the substantial question.
The matter, I'm trying this present appeal, my lord. As regard to my lord challenging the order passed by the first appellate court. That is the learned, my lord, civil judge, Sagar, in title appeal number 1 of 2021. Thereby reversing the order passed by the learned. Then Munsif number 1.
Yes. What is your case?
My lord. So
You are
my
the
case-
plaintiff.
I have the defendant.
Plaintiff is who?
Plaintiff is them.
What is the suit filed for?
For easement right, madam. My lord will find it. It clears that page number, madam. 21, my lord, starting from page. Of that page. They're praying for easement right over my property. The crux of the is that
So the plaintiff has claimed for right of use over the schedule P land.
you feel land with the source.
Now schedule B, this portion of the land, approach part of 3.60 meters.
My lord,
How much is the area?
that would be, my lord. Area I'll have to calculate. That.
What is the name of the plaintiff? It is Dihingia.
It is Dihingia.
Who are you?
I am the owner of this Schedule A land matter.
Huh?
I am the owner of Schedule A1 land matter. Schedule A1 land, and the plaintiff is the original plaintiff is the owner of the Schedule A2 land matter. And this particular road passes through Schedule
Wait.
A1.
You are the owner of?
Schedule A1 matter.
How do you know? Where is it?
Schedule is at page number 22, my lord.
A1 was sold to the defendant, number 2.
Well.
In the schedule of the state land quoted specifically and that goes through this with which is the portion of the land the plaintiff is asking? You are the plaintiff?
Yes, sir.
Which portion? Page 24.
If I may. Main.
Which is Schedule B?
If I may. Page number 24, my lord. In between Schedule 1A and Schedule 2A, there is a, my lord will find a gap. That's the key.
Whose land is it?
That is Originally, that is mine.
Huh?
That belongs to me.
Which one
This particular schedule P.
belongs to you? Then why you are asking for easement to it?
But they are asking for it. We kept it. I'm the defendant.
You are the owner of which land? Schedule A1 or A2?
A1, my
Yes, yes, plenty. Which is the land you are asking?
My lord, we are asking the Schedule B path.
Where is schedule?
Schedule B path, my lord, has this sketch map probably.
Page 24.
24, my lord. My lord, sees PC Borua Road on the right, PC Borapot,
Hmm.
and then towards the left, your lordship sees Krishnanagar Pot. There was a road, according to us, there was a road from PC Borua to Krishnanagar, which the defendant who occupies Schedule A1 has encroached.
Which portion?
My lord, this entire path, if your lordship sees, Schedule A1 is the plaintiff's property, defendant number 2, defendant's property. My allegation is he has surpassed this particular boundary and encroached upon this path,
The entire road.
entirely.
He has trespassed it.
Yes.
It is his land.
No.
Whose land?
Both of us have purchased it from intermediary purchases from the main original owner. Their sale deed said that there is a path existing there. In their particular sale deed, it said there is an 8-feet path. Now their contention is this 8-feet path is exclusively ours and it is not a common path. Now, my lord, during cross-examination, the defendant admits that all the electricity lines, my lord, poles, my underground water supply, drainage to my plot of land, which is A2, is also on that very same path. Taking note of that, the appellate court holds that it has to be a common path, and other evidence was also there that my vendor was also using that same common path for 20 years. So by right of prescription, it has come to
27.
25.
25. How much is the area?
3.60 meters.
Huh?
In fact, there was also an Amin commission appointed. Not on record. Amin commission says it is close to 3.76 lakh. 3.76 lakh.
And in whose land does it fall?
My lord, Amin commission observed that the defendant is in possession of additional 1 lakh than his purchase.
Irrespective of that land? Or irrespective of this land?
My lord, no, my lord, including this land, that is the allegation.
So, therefore,
He
the
was found in
defendant would
excess.
be in possession. If this is made common, then the defendant loses possession of 2.6.
Oh, no, the entire path, as per the commission's report, is 3.76. I am saying he's encroached the part in front of my house. Now, Amin commission report also says that he is in possession of additional 1 lakh of land, though he has purchased just 1 quota 4 lakh. Drawing the inference, the appellate court holds that he's encroached upon the part, which is
But
why
that is not defendant's land.
that is not difficult. And defendant admits that there is a path on my southern boundary, and my sale deed also depicts that path. But he says that this is exclusively for me, and this is not a common path. And I have another path, a motorable road from another side.
The trial court dismissed your suit.
Trial court dismissed.
Why?
Trial court, my lord, held that the right of easement is not available to me. Issue number 3 has been dealt with by the trial court at page 97.
Now, what has happened after the judgment passed by the first appellate court?
We are using.
Let us admit the appeal. No,
Well, they don't have an application.
Not filed any application. I think it
let's say, and
Well,
post it in 2035.
so there is a well, sale deed, my lord, as yet compared, I would like to submit,
No, Mr. Sensor, this is some portion somebody is using it. You have filed an appeal, good. That is necessary for a lawyer to do, survive. But then also, that is why I'll admit the appeal. But I think in high time this needs to be closed. Does it require such a long litigation for
my lord, there are certain contentious matters. They have not been using as yet submitted. They have not been using that particular road for that. In fact, they have been using that road in the sale deed. It has been exhibited as exhibit number 4. There is no mention of that particular road. In fact, they had 2 other motorable roads. Not using that, they are using this particular road. I have already, they have constructed.
What is the Amin Commission's report?
I'll have to share it.
Yes.
Page
What is the substantial question of law I should say? Let us get it from the defendant. Yes, what is it?
Well, they're proposing to.
They are proposing, none of it is a substantial question. That is why
My lord, there's number 3, my lord. It says section 15 of the Easement Act that I purchased in 96. So therefore, they probably want to contend 20 years is not over.
What?
At page 6.
The B is not there. A, he says, doesn't arise. B does not arise because your specific statement is your
Vendor also.
vendor was also using it. So B does not arise. Fail to appreciate 25 in the proper perspective cannot be a substantive question of law. Whether the claim of the Iman in respect of Yah would be ambit of the easement of Yah, so and so, not there. For that, there is a substance arises to determination, that is also not there. Well, how can I help?
Brave, my lord. Brave, my lord. I'm satisfied, my lord, that these are, my lord, issues that need to be tried. If I may take, my lord, for a minute, my lord, the sale deed that has been executed with him. The sale deed.
No, did your sale?
Their sale deed.
No, your sale.
My sale deed, my lord.
Did it have a path?
My lord, a particular path has been sold to me. It clearly says that. Whereas the vendor has agreed to sell, transfer, and convey absolutely the suit land along with an approach road of 3.60 meter breadth running on the southern side from the private road to the.
Who sold it to you?
The vendor, my lord.
Who is your vendor?
Originally, this particular land was the entire land, Ethan my land, was owned by one single person, my lord, Mohendra Narayan Sharma. Then thereafter, Mohendra Narayan Sharma sold this particular plot of land to my lord, one Mira or Kotoki, my lord. And subsequently, Mira or Kotoki, my lord, sold this to dependent, that is me.
No, wait. That Mohendra person, did he sell the 3.60? Because your vendor cannot sell if it is not been conveyed to the. And when was it sold to your vendor?
My lord, it was sold to me in the year 1988, my lord. 89.
And your vendor, when did your vendor buy it with the
1990.
your vendor? And you say, and at that point of time, your vendor sold it, did you produce it?
My Suborno said it, my lord. My vendor said it. That said it does not.
How do you prove that they have been using? Did your vendor come to give evidence?
No, vendor did not. My vendor, the original vendor's son came in support of my case. Mohendranath Sharma, he is the original owner. His legal heirs came and said that yes, there was a path, common path.
One party, I'm not concerned. Your vendor did not.
My vendor did.
How did you prove that your vendor, prior to 96, was using?
I made by way of oral testimony, my lord, of my.
How can you have an oral testimony? You don't know that.
There was no cross on that. I made that categorical statement both in the plaint and also in the evidence, my lord, that my vendor was also using it. He showed this path to me. Then I started using it. In fact, when constructions were made, this was used, and there was no cross-examination to that effect.
But cross-examination was not there because they have categorically made a statement. May I please read it? After purchase of my land in 1996, I constructed the residential house, which was completed in 2000. Since then, I have been residing there with my family, using the aforesaid approach path for ingress and egress to Krishna Nagar Port, with connecting connects the old Amalapati. So it is after they have purchased, they have constructed a house over it, they have been residing there, then thereafter they have been residing this particular house, using this particular house.
After 90,
After
96.
After 96, in fact, after 2000. After they completed the construction.
And when was the suit filed?
Suit was
2012.
filed, my lord,
13.
2013, my lord. Before expiry of 20 years, as per their period.
Because even if 96 is true, then
also
also it is not.
They're not perfect.
Because I don't think his vendor's son, original vendor's son, would evidence have any relevance? To admit this appeal by formulating the question as to whether the plaintiff would have been entitled to an easement free right in terms with Executor, taking into account the statements made in the claim and the suit having been filed in the year
2013.
heard me then. That was a little conflict after the PD declared a little conflict out of the result. This is an appeal under section 100 of the procedure directed against the judgment and decree dated 21/12/2022, passed in cycle appeal number 01 of 2021, whereby the learned first appellate court, that is the court of the civil judge, Sagar, had reversed the decision of the learned trial court, reversed the judgment and decree of the learned trial court dated 11/1/2021, passed in title 65 of the 2013. the appeal is admitted by formulating the following substantial question. Whether the plaintiff, whether the learned court, first appellate court was justified in decreeing the suit in favor of the plaintiff. In terms with section 25 of the Limitation Act 1963, read with the affirmance made in the claims as well as also the evidence tendered by the plaintiff. And more particularly when the suit was filed only in the year 2000. All for the record, taking into account that all the respondents are duly represented, it's the matter for hearing immediately.
Right.
What? Why? Sometimes
No, in the trial court, it was dismissed, and in the appellate court, it was partly allowed. They have now certified. The other plaintiff and the defendants are heirs of this Bora.
Hello. We have it on some other day. Is there any stay? No stay.
The appellant has significantly taken possession of the property. This is a land property.
Ah.
The number one is the daughter. Significantly, she's taking the property.
Hello. The appellant being not represented in matters adjourned for the injustice to the to such state to be listed after 2 weeks. SR Gogoi appears on behalf of that.
That's number one.
I was not aware of the matter, Your Lord.
Yes, what is the plaintiff's case?
My lord, my father, he was possessing this land, which was part of the
Bijni Raj estate. Then in 1954, when the Jamidari Act came in, Abolition Act, the land was acquired by the government in 1955-56, this land. And the tenants under the Bijni Raj estate became the tenants under the government. Now, the name of my father was inadvertently left out in the Jamabandi. So I made an application in the year 1993 to include my name because I was in possession of that land. Then my name was included and ultimately that Sarkari land was made Miyadi. I got a patta in 1990. Thereafter, my father died sometimes in the year 2001. In the year 2007, I get a notice from the Deputy Commissioner's office directing me to produce the documents by which the patta was issued to my father. Now, unfortunately, all the papers that I had was the landholding certificate and the patta itself that I produced. Rest I couldn't because it was handled by my father. I did not know where he kept it. Ultimately, the Deputy Commissioner wrote to the settlement officer that you conduct an inquiry as to how the patta had been issued. They came to the conclusion that some mandal at that time had tampered with the records, and my name was recorded, and in that way the patta was issued. So the settlement officer, by an order, cancelled the patta. Then ultimately I filed the suit. Now the question arises, my lord, that under Rule 26 of the Assam Land and Revenue Regulation, it is only the commissioner, right, who can exercise this power. If it is proved that the patta was issued in contravention to the rules framed under the regulation, not otherwise, no other officer. That the First Appellate Court has also dealt with by citing the judgment of our Honorable Guwahati High Court that the settlement officer or the assistant settlement officer cannot cancel it. Right. That is the substantial question of law that can arise, my lord.
First Appellate Court held that the settlement officer could not have cancelled.
Yes.
Right? The government can cancel it. The commissioner can. Now that the commissioner has been, there's an amendment to Rule 26. You see, the government can cancel it. But how can the settlement officer cancel?
Settlement officer.
So you are only against the settlement officer's order.
Yes, sir.
But that is not what you are asking for.
I asked for right title and interest, man.
But you have not challenged the settlement officer's order.
My lord, when this notice came from the settlement officer, then immediately I filed the suit. The
Understood.
order came
But
later
you
on.
did not challenge the settlement officer's order. How
Order,
could the appellate court set aside, grant you right title in interest on the basis of setting aside?
no, not on setting aside, my lord, because when I received the notice, then immediately I filed this. The order came later on.
Huh?
This circle officer's order, my lord, came later on.
So that is therefore not a question.
My
The
lord,
question is as to whether you have a right title in interest over the property.
yes, fine.
That's it.
Yes,
But why did the first appellate court go into the question of settlement officer?
it was raised by them. That is the plea, my lord, in paragraph number.
Why will they take the plea? Let us see what the first appellate court has done.
Para 7, my lord, of the WS, my
Forget about that.
page number 57, my lord, issue number 3 and additional issue number 1, my lord. They were decided together, page number 57 to 65.
Now, how can the court go into, did you amend your plaint?
No, my lord, as per what is
If you have
available
not
here,
amended the plaint, how could the first appellate court go into that additional issue?
additional issue was framed
Why?
by the trial
Trial
court
court,
itself.
how?
my lord. It is based on the plea taken by the state.
Understood. There cannot be a plea being taken. The plea, they may take many pleas. But the question is as to whether you have given any plea. You have not challenged that.
My lord, as far as the plaint is concerned, page 8, my lord.
I've seen the plaint.
I've stated about this thing, my lord, in the para 6, my lord. I've stated that. Not regarding the order, but as I had submitted, my lord, regarding the notice of the proceeding, my lord, for
No,
cancellation
but
of,
how did the court go into the question of that order?
based on, my lord, what the defendant had pleaded in para 7 of the written statement, page 14.
Defendant may have pleaded that, stated that, so wasn't it required for you to amend it?
My lord, in my respectful submission, my lord, that issue, my lord, this thing can be decided under the issue of right title and interest. my lord. Because I have claimed title on the based on the patta issued by the state. my lord. And the state is saying that I have obtained it by tampering of the records.
Whatever may be. But the question is, that is the basis on which he has issued, decided the issue number 3 and issue number 1. But there's no issue, there's no pleadings by you challenging that, but the cancellation
My
order.
lord, in the prayer it is not.
So understand, they may raise whatever may. But the question of framing that issue also did not come because you did not say anything. When is the issue framed? The issue is framed when the plaintiff says something and the defendant says the other. Then only it becomes a issue of fact.
I have stated about the proceeding in paragraph.
Wherever
number
the proceeding, we are not concerned. Here the court interfered, the first appellate court had only interfered only on the ground that the revenue authority did not have the power to cancel. That's how the issue number 3 has been decided.
My lord, how the additional issue was framed, my lord, I think I'll have to take instructions because, my lord, the suit was filed on 11th of March 2008 and the order came later on.
Yes, madam, you have a case.
Yes, Lord.
It is not for this court to find out the case for you.
Another date may
Huh?
another date may
Your name, you argue,
no,
not anybody else.
there's no cases there that
No, this is specifically your name I am putting it.
Oh, yeah.
No, you. Otherwise, I will
It has
put
been
it that
filed by you,
non-appeal
sir,
for
so
the
that-
state of Assam and will dismiss the appeal. You have to argue next day. Today is 20.
It has been filed by some other government advocate. You that.
That government advocate who filed it now has become a senior advocate and no longer, I think, appears. We will have to have a requirement of a change in the government, which is only happening in 2026. So till then, should we keep the appeal like this? You argue. I've given you the ground.
Now file is not at 2 or some other date.
Not today. I'm not today.
Yes.
I'm saying it. I'm fixing it on 24th.
24th,
You argue on that.
my lord, 24th, I will not.
Mr. Khattar is there who is on the side of you.
No, no,
Anyways, Mr. Mukesh, I don't require you
my lord,
because of the fact that you first I'll have to issue notice. I'll have to admit the appeal. Then only I hear you other side.
my lord, my lord.
The good that you have put in your appearance, the expenses of the state is being duly met. Miss Kepuka submits that she is not prepared today to do the matter. However, she submits that the matter, she would be prepared to do the matter on 24th of May. accordingly list the matter on 24th at the stage of order 41 rule 11. You say your substantial question of law you have to argue that you see that is never an issue. Court could have framed an issue, but that was never challenged. And issue number 3 and additional issue number 1 was the basis on which the first appellate court decided. That could not have been without a challenge to these orders.
Obliged.
Transfer, who wants to go where? Yes. You want to go from where to where?
My lord, wife is seeking my transfer, my lord, of divorce petition filed by husband from the Mongoldoy to family court Kamrup.
Where?
From Dorong to Guwahati. The husband has filed the divorce case at Dorong. I have the wife, my lord, on maintenance case pending at the court Kamrup.
Kamrup where?
Family court Kamrup. But the maintenance case
Mr. Counsel, I don't understand one thing. At Dorong, you can appear through your lawyer. You will come every day from Hazo to appear here. See, the inconvenience is isn't it more here? Coming every day to here, whereas here you can't have a lawyer. On the other hand, you can have an expertise of a lawyer there. Isn't it easier for you there? I would have understood you are staying in Guwahati for that idea, but you are staying in Hazo. Then every day, whenever the matter is that you have to personally come here if we transfer it. Wouldn't the inconvenience be more for you? Spoil your voice. Or my voice is too much for you. Yes, tell me. The petitioner will every day like to come from Hazo to Guwahati to appear. Fantastic. How much is the distance? 30 kilometers? 35 kilometers? She has no problem. But she has a problem in going to Darok once or twice during the entire process, where it can be very well represented by the council. Then yeah, it's a family court, section 13. She has to come every day. I can't excuse that. It is a statutory mandate. But in Dorong, you can appear through your lawyer. And it is only on the date on which you need to file your cross-examination or the court wants your presence that you'll have to appear. And what do you do?
We will file objection. We will file objection.
I'm not concerned about your objection. What do you do? What is he doing?
He is a Chief Transportation Inspector for the Indian Railway Department.
Huh?
CTI, Chief Transportation Inspector.
Government?
Government Indian Railway.
Yes.
Posting is
Whenever she goes, pay 3,500. I'm not transferring it. Let it be there. You will only go on that day on which you are required by the court to appear. And otherwise, you will be entitled to appear through your advocate. And at the time of cross-examination, whenever you will go, he will pay 3,500 to you. Win-win for you. And that is exclusive of other litigational expenses or maintenance expenses.
I'll have to ask my senior.
What?
I'll have to ask my senior. My senior is coming.
Who is your senior?
Mr. Pija Soikia. Mr. Pija Soikia.
PJ Saikia. So, is he going to help it? He comes, Mr. PJ Saikia, they have employed, we should make it 6,000. Ask him to come, we'll make it 6,000.
No,
That's two, we'll take it. No. To PJ Saikia, I would do. We'll make it 6,000.
No, Lord.
Because he has the power now to engage a senior because he has more money. We'll make it 6,000. We'll take it away too. 6,000. You have, I'm not going to transfer it. Either we transfer it here, then also you pay. He has to come all the way to from Hato. Then it is 3,500. If he has to go to there, 6,000.
Lord, 3,500.
Then? Transfer koribo. He will, taking into account that Section 13 of the Family Courts Act 1984 shall not apply. The petitioner shall only appear on such date which may be required if the court directs the appearance of the petitioner, and otherwise the petitioner would be entitled to avail the services of counsel, or for cross-examination. In addition to that, this court also, in the interest of justice, finds it that the petitioner would be entitled to an amount of rupees 3,500, which the respondent herein shall pay on such day when the petitioner has to appear before the court at the Dorong, before the court of the where the matter is pending. Because of the above direction to make payment of rupees 3,500 shall not preclude the petitioner to claim litigational or maintenance expenses which she is otherwise entitled as below. Petition stands disposed, not transferring. You saved your client from 2,500.
Is it Lordship? Whether may be taken at 2 p.m.
Why?
Mr. S. Koenig is indicated.
Who?
S. Koenig.
So what?
For the margin purpose, he went out with the court. Is coming, just waiting for his turn. But
What is it challenging?
maybe taken at 2, my lord.
What is it challenging?
Lord, here this an
DRT order.
DRT. In fact,
What is that DRT order? Section 36.
36 million. In fact, there was a delay of 126 days.
For what?
In filing the application under section 17(1).
Then
It was rejected, my lord. I guess that they have come.
what is the ground explained?
Ground is, my lord. In fact, the ground they have said there is a delay of 46 days, 43 days.
43.
Yes, my lord. In fact, page 23, and it's a C is
Then?
the application.
Why we should not allow?
The only
I
thing,
think
my lord,
this should be allowed, then it should be dismissed by them. Section 17 should be dismissed.
only thing, my lord, here, probably, my lord, the DRT, my lord, has come to a conclusion, my lord, that taking into consideration the petition bench order of the Calcutta High Court, that section 5 is not applicable in case of 17(1). And in fact, there are decisions as well. And it is presently, my lord, sub judice before the Honorable Apex Court also, my lord. In the case of KJ George versus another, the authorized officer Indian, that is fixed on 9/7. Whether the, my lord, section 5 would be applicable in case of application under section 17(1).
What does 17(1) say?
Lord, this is
It does not say anything.
my lord, in fact, no, my lord, the only thing is 17, my lord, the limitation is there itself in
How much?
17. 45 days.
Then what is the language used?
I'll just read out. Any person, including borrower, agreed, or any other measures may refer to in subsection 4 of section 13, taken by the second secured creditor or his authorized officer under this chapter, may make an application along with fee as may be prescribed to the debt recovery tribunal having jurisdiction in the matter within 45 days from the date on which the such measures have been taken. So,
Then?
so this is then, in fact, they file an application under that is 36.
And if the Limitation Act applies, then
Lord, in fact, this is under dispute now.
no, as per the DRT Act, the Surface Act, Limitation Act applies.
Not fully.
Why?
Insofar as that is what the line below. Because below again below the section 25 probably of the recovery bank due to
No, we are to go not to the and per the Surface, because section 17 has to be read with the DRT Act. DRT Act provides limitation. And if limitation is prescribed out there, irrespective of whether you say that section 5 will apply or not, by dint of these, section 5 is applicable. So, what is wrong?
In fact, Lord, in British sub judice before the apex court now.
So what?
That point. In fact, there are two, I will have two decisions of the Milord. One is the Calcutta High Court, another of the division bench of the Madhya Pradesh High Court. He says that Milord, it is not applicable.
Very well. Let's see. We'll take it up at 2.
Lordship.
Yes, Mr. Manik.
Wait, is the picture. Sir, as I addressed the law point, it might go in
Forget about the law point. First, the question of jurisdiction of this court.
absolute. The short point itself for consideration is whether in an adjudication of an application filed under section 71 of the SURFACE Act, the provisions of section 5 of the Limitation Act is if it is applicable, then my case was wrongly decided. If it is not applicable, then it should be dismissed. Correct. Of course, the learned timing also went to say that day-to-day explanation ought to have been there, but that is subsequent. I would not address on that. But firstly, whether it is attractive. If Limitation Act is not applicable, section 5, besides, then perhaps the order is correct. But in my endeavor to satisfy your lordship, there might be judgments, there might be issues which are against. I'll address them. Lordship,
No,
will
you
take
see, the reason why the division bench of the Calcutta High Court has done it, they have taken on the basis of Mardia chemicals,
I will
wherein
address that.
Huh?
I will address Mardia and Travancore was considered by the Calcutta High Court while deciding Akshat.
no, the
2010.
reason why Mardia considered it to be a original application, but have taken it as an original application. Kindly see. Mardia considered that as an original application, not an appeal.
Therefore, the amendment.
Therefore, the amendment came, it's okay. But the reason why the pre-deposit is not necessary is the basis on which it was said that it is not an appeal.
Correct.
So Mardia was decided on that basis.
That
Now, otherwise, if it is an application, because normally in a suit, section 5 is
Not-
not applicable.
not
There's no quarrel with that.
would be in a judgment by your lordship also it is there. If 14 comes in, 14 comes in, then 5 comes. In a suit, yes, that would be an
No,
exception.
there is obviously there,
Obviously.
because section 3 categorically say in a suit 5
In a
or appeal prefer or an application 5. So then if that is so, section 5 to 29, 24,
4 to 29, if I pick up.
4 to 24 would be applicable. Now, if it is an application, why not section 5, taking into account that the
I'm supporting section 5.
yes, I'm
He is
also
opposing.
supporting you.
My contention would be otherwise. Because I have to address if Akshat. Akshat was the ground on which this my prayer was rejected.
Hmm.
I have to address it. Before that, if we take the mischief rule of it, when the banking system was on in India,
Now, just for example, let me tell you. There are many matters which are filed under 226 challenging the jurisdiction surface equity. And we refer it back to or render or relegate the party to go to section 17. And we give them a time. Under what powers do we take?
these are past exercise under 226, but no one brings it to the notice of your lordship that there is a point of limitation which needs to be addressed, because even if my lord
exercises 226, lordship may not be having the jurisdiction to say to institute a suit after 3 years or whatever period of limitation is over. This point did not crop up earlier. Therefore, the outer thing can be, but this should be addressed to your lordship.
No, the question is,
Question is that was not
a
not be considered.
limitation, there are many judgments of the Supreme Court where a limitation normally bars. You should not exercise to it.
Correct.
But the Limitation Act does not apply under Article 226.
Doesn't it?
So the powers under 226 cannot be controlled or circumscribed by the Limitation Act.
Or if I put it this way, lordship does not have the jurisdiction to issue a writ of mandate. That is with the Queen. It's in the nature of mandate, which is being exercised by your lordship. So therefore, once Constitution came in 19, it's not my subject here. Once came in, and then the writ courts came in after the 1961 High Court Act, then the powers exercised by this court were in the nature of mandate. In the nature of mandamus does not give a jurisdiction, with all humility, to an honorable judge of a high court to extend the period of limitation or prescribed period as the case may be. This question is always fatal when it comes to a suit. But so far as tribunals are concerned, the contesting parties having not, in most of the cases, either taken objection to or addressed this issue, it never came up. Ultimately, when the matter went up to the apex court in a different matter, now it is being looked into whether Section 5 is applicable. If Section 5 is applicable, then the trappings of a court or whatever we call it, the application part, that would get delegated to an application simpliciter and Section 5 will be applicable. Discussion part, contraction. But if the apex court holds that no, it is not applicable, then Mardia will come in, Travancore would come in, and then it would be of the original nature.
No, Mardia and Travancore doesn't say.
Absolutely, that's my point.
Doesn't say
Doesn't
that
say.
it is a Section 5 that doesn't apply.
It doesn't say so.
It only says that this is an original application.
It says it's an original application, number one, and number two, but for the bar of Section 34, suit would have lie. Suit would lie. Suit would lie, but for the bar of Section 34, here it is given. But it cannot be an appeal. It has to be of an original nature. This point is taken forward after the amendment. Travancore comes in when the note is not changed. The note to the section is not changed. There it remains appeal. Now Travancore comes to say that no, this is of original jurisdiction. Taking a cue from Mardia and Travancore, Calcutta High Court Division Bench proceeds to the premise that if it's of original nature, original application, then in that case, it would be a suit on the first instance. If on the first instance, it is not, Section 5 not applicable.
Then what do you say about the application for probate? Are you considering it to be a suit?
If contested.
Contested, forget about the contested. But are you saying it to be a suit? No.
But here,
So then 137 applies,
apply. Here 137 would not apply.
which has been confirmed by the judgment out here has been confirmed by the Supreme Court.
Here 137 would not apply.
I'm not
I get
concerned
it.
here.
I get it. I get it.
So filing an original application does not mean that it is a suit.
Absolutely correct. That was what I would be submitting. But I have to substantiate my submissions with facts, laws, and argument.
So you're not ready.
I am ready.
Then argue.
Lordship. When the banking system was prevalent in India, I'm just going the fact. There was not a systematic way under the law to recover the loan. That is when the 93 Act came, gave the power to the bank to recover the loans through an application to a tribunal. Now, 93 Act recognized this power that if you have to take measures for recovery of debt from a borrower, you being the secured creditor, you can approach the tribunal and the tribunal would be called a debt recovery tribunal. This procedure for, and they had the appellate tribunal also, DRAT also. We traveled down to 2002, where it was noticed that This system that the person defaults, takes loan, defaults, his mortgage property is there, and banks to get back on the business is not working out. Then they moved on to 2002 Act, where the securitization concept came in. The bank or financial institutions need not approach the tribunal. They can, on their own, initiate action, which is given in 13.2, 13.4 measure. This power was given with the SURFACE Act. And now, the borrower or any person could approach the court, the tribunal, this DRT, under Section 17.1, within a period of 45 days, if he is aggrieved by any of the measures initiated by the bank or the financial institution. It is in this context the 45 has come. If I take the DRT Act, if I may put it that way, I mean the 93 Act and the 2002 Act, since under the 93 Act, the bank had to approach, there was no question of limitation. The point of limitation was not. But since under the
No, there's a limitation on the counterclaim.
I want it.
No,
The
no,
bank has to-
no.
Under 93
Maybe,
bank has
but
to-
there is a counterclaim can be filed.
No, we are on the action by the original filing. The bank has to file under the 93 Act. A person would not file. Since the bank has to file under the 93 Act, there was no question of limitation. And in the same tune, there was
No, there has to be a limitation.
May-
Why
may
you
I-
are saying there is no limitation?
May I invite
Like,
my
can a bank file after 100 years? No,
Exactly.
no.
That was taken care of by the SURFACE Act. I'll address you a lot.
No. Bank cannot file. Bank also has to file within time. You can't say that. Limitation Act duly applies for bank also.
Correct. But so far as the initial filing of the application is concerned,
Kindly, Mr. Boni, kindly don't confuse yourself with a bank filing an appeal and a particular giving a particular limited period of limitation of 90 days or 1 lakh or 30 days for filing an appeal before the DRT. That is a different aspect of the matter. But here we are concerned with an application filed by the bank for under the original jurisdiction, under the an OA. And if it is an OA is being filed, it has to be filed within this limitation that is 3 years or whatever may be the period. The bank has a limitation.
that was taken care of by this 2002 Act.
No, 2002 Act is on a different score.
Different form, but it touches upon that part that if bank also takes measures under 13.2 and 13.4, it must adhere to the limitation. It will jump over. That provision is there.
No,
I consider
bank's
provision is there.
limitation is already there in the 93 Act also.
Very-
And here also it is categorically mentioned that the limitation aspect is also one of the passage which needs to be. Just for example, a bank after 10 years cannot come up one fine morning and look here that we are going to initiate action under 13. You can't. The bank has to do it when the liability or the liability on which the bank is trying to take action under the SURFACE Act is within the period of
Correct.
limitation.
Absolutely. I go by. Now, since the nature of applications under 93 Act and 2002 Act are distinct and different, 2002 Act by the borrower or any person, it's a human being who's aggrieved or a company whose properties are mortgaged and action is being sought to be taken under 13, approaches under 2002 Act
Not sought to be taken,
Initiated.
has been taken.
has been taken. 13.4 steps has come in after the correspondence part. Then the 45 days period indicated is a time period within which you can preferably file an app. It does not talk that Limitation Act, this being a special law, is excluded or nothing can be done. That was the precise point taken in one of the cases. If I may invite my lord's attention to the Limitation Act 29.2.
29.2 is on a larger scope.
That was taken into consideration, Mila. If I may-
29.2 says where another law which is there, which does not exclude the Limitation Act, and it prescribes a particular, it does not prescribe a period of limitation for that, then the limitation which is given out there in the Limitation Act will apply, including the provisions of Section 4 to 24.
Yes, but may I read it once and then place the judgment?
Yes.
where any special or local law prescribes for any suit, appeal, or application a period of limitation different from the period prescribed by the schedule. The provisions of section 3 shall apply as if such period were the period prescribed by the schedule, and for the purpose of determining the period of limitation prescribed for any suit, appeal, or application by any special or local law, the provisions contained in section 4 to 24 shall apply only insofar as and to the extent which they are not expressly excluded by any such special or local law. This exclusion part of
It's
the-
not there.
is not there. If it is not there, then the application does not take the nature of a suit, and the tribunal established under the 93 Act is not a court. Then Limitation Act would pressed into service, section 5 on the merits. Learned tribunal erred in law, because it's a revision application I'm expressing in appreciating this aspect of it. Perhaps not placed or anything, but anyway.
Because the fundamental,
Fundamental thing,
no, Mr. Bonik, the fundamentals of the court, with due respect, of the Calcutta High Court is wrong because of the fact that it has construed it to be a suit. It couldn't have been. A suit has to be on a different aspect. It has to be it may be an original application. Just for example, a cat. Simple. It has an original application. So original application, there is a period given.
Gotcha.
That if something happens out there, you have to prepare within such a period. Or from there, or if, just for example, an appeal is being provided from 17.
Gotcha.
What is the appellate jurisdiction under 17? I think 19?
Yes.
Yeah.
Eighteen.
Hmm.
18. When both the acts get overlapped, so the sections. So on the touchstone of 29(2), the judgment.
What is that? Appeal?
Any person aggrieved by any order made by the DRT under section 17 may prefer an appeal along with such fee as may be prescribed to the appellate tribunal within 30 days from the date of receipt of the order of the DRT, provided that different fees may be prescribed for filing of an appeal by the borrower or by the person other than the borrower. Provided further that no appeal shall be entertained unless the borrower has deposited with the appellate tribunal 50% of the amount of debt due from him as claimed by the secured creditor or determined by the DRT, whichever is less. Provided also that the appellate tribunal may, for the reasons to be recorded in writing, reduce the amount to not less than 25% of debt referred to in the second provision. Save as otherwise given in that, the appellate tribunal shall, so far as may be, dispose of the appeal in accordance with the provisions of the Recovery of Debt Due to Banks and Financial Institutions Act 93 and there was one argument against. I must place it before your lordship. This is on touchstone of 29(2).
What does it say?
Paragraph 7, page 9. May I read? This court need not go into the prolixity of considering various judicial pronouncements of different courts to resolve the controversy herein, because the answer to the question framed above lies in the bare reading of section 29(2) of the Limitation Act. Section 29, containing the saving clause, lays down various contingencies in which different nature of causes of action arising on the different enactments can be prevented from becoming time bar. Section 29(2) inter alia stipulates that if the special law does not expressly exclude application of section 4 to 24 of the Limitation Act, then these provisions of Limitation Act shall apply qua all causes raised under the special law. The special law, that is SURFACE Act, does not expressly exclude the application of the provisions of section 4 to 24 of the Limitation Act, including section 5. And therefore, the benefit under section 5 of the Limitation Act shall be available to the cause of action raised in an application under section 17 of the SURFACE Act. That's now applying the aforesaid principle of law to the fact situation attending the present case, it is obvious from a plain reading of the SURFACE Act that while prescribing the period of 45 days for filing an application under section 17(1), this special act does not expressly bar the application of section 5 of the Limitation Act.
No, in fact, the judgment of the Supreme Court was on 18/2.
Judgment of the Supreme Court was on 18 to 30, that period. It says even if we do not go to the Limitation Act, by virtue of 20 subsection 3 of the DRT Act 93, it can be gone down. That was the reasoning given. Yeah. That was, I do not have a judgment with me. Possibly 2016 1 SCC 444.
Which one? That one.
That one. 16
That has been taken into account by the Madras Judge.
What in ethics court now they are praying is that the reasoning of that judgment 18(2) and 3 should be borrowed and placed on 17. In my humble submission, although I'm not in the case, that would be wrong because that is on 18(2), and 18(2), the 23 of the 93 Act has a built-in provision of condonation. Since that built-in provision was not there in 17, and 17 was being proceeded all along as a suit, therefore the difficulty is stopped.
It is never a suit. It was
not
no.
never.
Who has considered it to be a suit?
From Akshat, the interpretation of given by Akshat of Mardia and Travancore has given to this.
No. The question is, you see, the Supreme Court has never considered it to be a suit.
Never.
It says that it is a form of an original application, and as such, the question of, and it was on the context in which it was said, you don't need to pay this 75%.
Correct.
Because it is not.
No.
So it is not an appeal, because normally a pre-deposit is attached to an appeal. And as such, it was said that it will be considered to be an original application, and as such. If it is an original application, yes, why not the limitation pay in view of 29(2)?
Yes. That's a respect.
The only thing, my lord, since the, my lord, I has been dismissed. So, my lord, who did not result in dismissal of the main section 17 application. If that is so, then it is under section 18, an appeal lies before the dread. It is the first point. And second thing, my lord, I'll just
That he has already answered, no? That is the question which I have also put it.
yes, my lord.
So he have answered that here is a question as to whether section 5 applies or not, and as such the judicial interpretation is being sought. But if that judicial interpretation is being sought, can I do so under 227 and not 26?
Only thing,
Because the power would be a supervisory power. Would this court have the jurisdiction to do that? 226 I can.
May I put it this way?
Hmm.
Appeal to the
Yes, this
appellate
is the
tribunal.
judgment he has shown.
if a lot, the only thing, page 4, my lord.
Page
Page 4, my lord.
No, thereafter the judgment has come in this case.
It is in fact, this case is fixed on 9th of July.
No, there is another division bench judgment.
No, this is, that is probably the Calcutta High Court. This is what I am referring is SLP, which is pending before the Supreme Court.
Which one?
Paragraph 4, page 4, 2.1.
Yeah.
On this point.
Yeah.
Cause for doubting the presidential value of the decision in Anirudh Singh was that the coordinate bench of this court, while dealing with Anirudh Singh, failed to consider the earlier contrary view of the effect by the apex court in the petition. Since the same was rendered clarity for inquiry. The earlier edition of apex court. What is this apex court judgment? 2008-7 assessment.
Paragraph 4. Paragraph 4. Consolidated engineering enterprise. Okay.
No, that is okay, but here I don't understand. If it is a question of law involved, why can't the court under 226 decide? There are plethora of judgments of the Supreme Court where a question of interpretation of a law is a reason. The court should not, more particularly if you see the Godrej Harali judgment. Supreme Court makes it clear when it is a question of interpretation as to whether, for example, in this case, Section 5 of the Limitation Act, why not? As to whether the applicability of Section 5 to the Section 17 of the Surface Act is a question of the interpretation. How can the appellate tribunal decide that?
Jurisdiction is not there.
Can the appellate tribunal decide that if it is a question of law?
So even otherwise, section 18 says
I don't agree with the division bench judgment in Madhya Pradesh here. But the question is, can this court under 227 exercise its jurisdiction? I can't. Because here the court will be exercising only the superintending power, not the powers under 226. 226 power is the different.
if I may address the law, if I may try that. So far as section 18 of the Surface Act is concerned, it starts with that I have to be aggrieved by an order by the DRT under section 70. This order is not under section 70.
No. That type of argument wouldn't hold
This is
water.
not on the
Mr. Banik, these type of arguments doesn't hold water because of the fact that once your application for condonation is dismissed, it amounts to confirmation of the actions, which takes the same the flavor of the judgment in pertaining to a an appeal. In an appeal, the Section 5 application is dismissed. Then the appeal gets dismissed, thereby amounts to confirmation of the order passed by the trial court.
But if I may take it this way, when we file SLP, putting it this way, when we file SLP and the SLP is dismissed, the SLP is dismissed. The main thing is not dismissed on merit. We can still come back and file a review application out there. So dismissal of the SLP does not amount to merger. of the-
Very well. This argument would hold water in Supreme Court. Let me dismiss your case on that.
But
And
this-
then
but
you
this
can
point
very
is
well
brought
argue.
up now.
Mr. Bonik, don't stress it to that extent of the SLP. It is a good thing that one would like to always have a, when you are presenting, you come up with different ideas, but then also isn't this too far-fetched?
I leave it to you alone.
You see, the only thing which the only problem which this court is having is, can this court exercise 227? And then interpret the law. You see, power under 226 is much more. 227 is very circumscribed. how do I exercise 227? 226. I don't agree with what Madhya High Court said, that relegating under 18.2
Yes.
of an appeal. Obviously, this point of law cannot be decided by here. Now, now, just for example, how do I, most important thing, here the court have relegated the party to go to under 18. Keeping this matter pending from 2024, 2023 to March 2024. Period of 30 days is over. Then how do you apply
No, that has been
Limitation Act?
that has been taken care of later,
How? Thereby giving the liberty somehow?
4.1 million.
That is what is the power is being exercised? Tell me.
So this was on probably
Within this court, that means, don't you mean that the court under 226 have enlarged the period of limitation, which is specifically reserved out there for the DRT?
very similar. This was an application under 224.
So therefore, how could that be done, if at all? If you are saying that we, section 517, you cannot do so. If he had, just for example, Mr. Day, if he has come under 226 and challenged the surface action, I can very well ask him, no, I'm going to dismiss it and relegate you to file within 30 days. But if he directly goes there, he cannot. Tell me, is it justified?
That is good.
Is it reasonable? So, Mr. Boning, you kindly address on one point, how do this court under 227 exercise the jurisdiction to interpret this law?
Of course, the power is there.
Power is there, but can this court exercise?
I get
This
it.
will be otherwise a bench format.
May I put it this way?
I don't have the roster for that.
If in a case of revision on the Article 227, if the Honorable Court notices that there has been a jurisdictional error, that must no point.
No,
That has
no jurisdictional error. It is not the case where the court have or the tribunal have exercised the jurisdiction in such a manner shocks the judicial conscience. This is how. It is a different thing. We are very liberal, taking into account your faces, that we have to do something as regards this. But otherwise, it is a case where it needs to be 227 is not to be exercised just at the throw of the hat or at the drop of the hat. You don't exercise. But here, how do I interpret? You see, you have Godrej Sarali for that. It's a question of law. Very well, this court can very well interpret. But how do I do it? Yeah.
That issue needs to be addressed by both of us again.
Who?
So-
By whom?
By both of us.
Why? You only.
But it is not.
No, he. You see, then we come to 101. The burden is on you. You want a judgment in your favor. He doesn't. He will only sit down.
Because when we move the matter, this Honorable Court entertained the matter, granted us a stay, which continues. Today, when the matter is being heard rightly, question has cropped up. Not on the merits of the matter, on other grounds.
This court was very kind enough to do that. Let us do one thing.
I need to address that point differently.
Yes, very well. We'll do one thing. We'll fix it on.
Otherwise,
No. We'll fix it on 7th.
Lordship, if Lordship recalls the matter.
No. The reason is specific. I won't be here on that day. And there is a likelihood that the Honorable Court who granted this thing and entertained it would may able to again
Lordship
take
takes it
into
whenever
account what is.
Lordship has heard the matter. It may be part of
No, nothing.
We'll agree to it. But one thing, if I may just point out, beyond this, there was a matter decided by a Lordship when the person, after all these years of pursuing in the civil suit, later on the bar of 34 was pointed out and it came to here, travel here. Then of course, Lordship holding that the bar of 34 would come. But since he was pursuing relentless, granted the benefit of 14 and the 45 days to count from the date of the order.
That I can. No, 14 I can very well. But the problem with these is different. Because 14 for a suit, it is there. Kindly appreciate that. 14 I can, because here is a person who filed a suit.
14 for the application.
Understood. No. 14 is a case of a suit. You see, if a person files a suit,
I got it.
in that case, I think when Mr. Samaria was appearing on this matter on one side, and or Mr. M. Mukesh, no, A. Ganguly or Mukesh Sharma was appearing, I remember, where he came up with that particular plea that the suit was barred under 34. He filed an application for rejection of the plaint that was disallowed, against which the matter came. I said that yes, it is barred by limitation and as such. However, taking into account 14, I gave him the benefit to move on. But this is 14 is applicable to a suit. I remember.
Here is a matter when we have traveled to the High Court challenging the order, the reasoning of the order, not on the merits of the matter, otherwise.
Because if you see the Limitation Act, Section 5 does not apply to appeals, suits. That is the reason why the problem is.
But if Lordship holds that Section 5 is applicable, so far as application is concerned.
Application is.
Absolutely. If Lordship holds that much only, that Section 5 is applicable so far as application is concerned, under the DRT Act and the Surface Act, it is an application, whether or not original. Therefore, Section 5 is applicable. That would take it.
For not preparing an appeal or not making a application. Whereas Section 14 is different. Section 15 also includes the
jurisdiction, in a court without jurisdiction.
Yes.
So the Lordship protected.
I will protect you. I have good intentions of protecting you. The only thing is, the problem with it is how do I exercise 227? Tell me. We'll have it on some other day, but you have to answer to that. How do I protect you under 227?
But if Lordship holds that this, by plain reading of the provisions of law, that DRT established by DRT Act of 93, to which applications can be filed.
And what is the judgment of 2006, this Madhya Pradesh High Court referring to?
2006?
It goes contrary to this, has not as such held that the earlier judgment to be for Incurium, 2007, 8-7.
2008-7 SCP, 167.
We'll get to that.
I'll have it with. This is a judgment. How is this judgment applicable? The story part is that the person who wrote the earlier judgment has also written this one. But how is this 2000 consolidated? What is that? The judgment the engineering is at all applicable? Because this was a case under 34.3. Now, 34.3 of the Arbitration Act specifically bars that you can't file beyond this time, and which have been held. But where is a bar on this one, the 17? But you have to answer 227.
Addressing that part in actual Miller. So far as 93 Act is concerned, it creates tribunals and mandates filing of application to tribunals by the bank. so far as 2002 is concerned,
Hmm.
it refers to the tribunal established under 93
Hmm.
and under section 71
Hmm.
mandates filing of application to such tribunal.
Hmm.
And section 24 of the DRT Act says the provisions of Limitation Act 1963 shall, as far as may be, applied to an application made to a tribunal.
Hmm.
If it's a tribunal and if it's an application, regardless of it being original nature or not,
They
such a
make
kind
an
of
application along with such.
Huh.
So then,
fees would be different. On
this is not a suit. You
It's not a
can't
suit.
have this as a suit.
It's not a suit. If it's an application, lordship may hold it that way and then decide. From the
an
point of law, on the face of it,
It can't be a suit. Hello, we'll have it when?
lordship may decide the matter. Lordship has heard the matter. That's it. Nothing more to argue. on
No,
both sides.
I don't keep I don't keep saving. The judgments comes only in the court itself, not today. When?
Any day for orders,
We'll have it on 30th, the 23rd is closed, huh? 28th. 28th will pass the order in the court.
so we need not address any further.
You want to address
No,
very
we
well.
need not.
You don't address, this court may be still thinking about 227. Why should that
Anyway,
matter being heard at far? And list the matter again on 28/5/2024.
all right.
Doing it as part of interim orders past the relation continue till the disposal of the matter.
In this case, my lord, what happened? A probate case has been filed against me.
Hmm.
Now, my lord, the will was in 2013. The person expired in 2014, and they filed a probate case in 2021. Now, their stand is that, my lord,
Will is of
will 2013, person expired 2014, they filed the probate case in 2020. Their stand is that they came to know about this all facts in 2019. So therefore, they filed the probate case along with the limitation petition. Now, limitation petition, the issue which has been answered by the learned court below, that the days from the days of knowledge, the limitation will start. Lordship note well that in 1926 Act, this limitation is not prescribed. Therefore, 137 Article 137 comes to play. In terms of that, my lord, the days, the right to apply accrues from the date of death of the person.
is it?
Yes, my lord, there is judgment, but I would say.
To
No.
me?
Yes. Now, lordship,
Our High Court?
Supreme Court.
Ah.
Supreme Court relied up, set up, uh, 2019 yes. Now, lordship, kindly hold for a moment paragraph 12. What is the interpretation that is given there to
Paragraph?
12, page 7?
Ah.
That Indian Succession Act 1925 does not prescribe a specific period of limitation for the grant of probate or for moving an application for cancellation of probate or letter of administration. The residuary entry Article 137 of the Act, which covers the proceeding for which no period of limitation stipulated in this Act, provides for a 3 years period for limitation. Article 137 reads as follows. These are the interpretation. Now, lordship may see the paragraph 14, page 8. That one judgment has been relied upon, Kerala State Electricity Board. Next. Paragraph 14, madam. Applying the ratio of Kerala Electricity Board Supra, the court in Kunalji Singh, Kanpur, Supra observed that the crucial expression in petition the right to apply in view of what has been stated by the court. Article 113 is clearly applicable to the petition for grant of letters of administration, as rightly observed by the High Court in such proceedings, the application merely seeks the recognition of the court performance duty because the nature of the proceeding it is a constitutional right. Next line is very important. The court then approved that the right to apply for probate accrues on the date of the death of the judge. The same ratio, my lord, paragraph 17, my lord, the petition which has been earlier rejected. Now, lord, the second point is also important.
Yes.
Second point is that, my lord, they otherwise, my lord, if we counted from the date of knowledge, Lordship, kindly have a look for their petition for a moment. Reputation petition. Let's start from page 28, my lord. Now, page 28, my lord, paragraph 5, start from page 29, where they have, my lord, made their observation. Paragraph 5, page 29, that there is no any deliberate or intentional lapse or negligence on its part in making the application for grant of probate. In fact, the right to file the probate petition recounts only which is effected from 6/10/2020, being the date of his knowledge and not from the date of death of the late Barula Bala Paus. My lord, downside, there is a days was 1443 days, my lord. My lord, I have given a chart. Otherwise, also, my lord, the delay is, my lord, 2184 days. If we count from the date of death and the days comes 2184, and if we count from the date of knowledge, my lord, that is 6/10/2020, my lord, they have filed this application on, my lord, 15/3/2021. The days come 160 days. Totally, I have given the chart of that.
Where?
One sheet I have put.
Sheet?
Along with that on top, my lord. Other way. Total. Therefore, from this both point of view, it is very much discernible that the learned court will not expect to apply its fine.
From the date of knowledge, why? How does it become relevant? Because they filed it in 2021.
Exactly, my lord. They have filed 2020. It is their assertion that since the date of knowledge is 6/10/2020, and they filed this application of probate on 15/3/2021. If suppose if we pick this plot for a moment, my lord, then it comes 160 days as per their stand, my lord. Now, if we take otherwise, my lord, from the date of death, my lord, then, my lord, I have given the chart, then it goes to show 2185 days. But they have shown as 1443 days, my lord. I don't know from what fact, my lord, it has been asserted 1400. No,
So they made some mistake in calculating.
Mistake, but then
They did not. They removed those periods, no?
Which period? Here.
From no, that period of 2000, all these things, COVID and all.
No, my lord. Otherwise, my lord, take it that the COVID may be exempted, but days must be clear, my lord. Suppose that period may be, my lord, exempted for the count of. And there is no explanation. Even their
Maria,
petition-
kindly don't say that, because in most of the applications on the section 5, which I get it, the date which they mention is different from what is found out by the office.
My lord, 16 months is, my lord, period which has been exempted. There is no problem. Question is that, my lord, date, the date has to be, my lord, calculated. If suppose if hold their stand for a moment from the date of knowledge comes first. If otherwise, if my stand would be goes, my lord, that from the date of this, etc., my lord, then it goes 2185. Might be there are so many reasons of that comes under the domain of sufficient force. Now, lordship, can you look the judgment, improved judgment, page 43. Property part start from the next paragraph. The petitioner in petition is shown various. Nothing, my lord. Whatever they have stated, that is, my lord, confirm.
Who is Mr. Tariq?
Tariq, my lord, Tariq is the advocate lordship from whose position that copy has been, my lord, there is no doubt a story has been prepared. We will not go to that side. 2013 he came to know 2019 from some source.
Where is the will?
My lord, will in page. My lord, page 21.
Page?
It is in
Page.
page 18, lord. Page 18. A good story has been created, my no doubt. My lord. A family member doesn't know, it's a very surprising element. My lord.
Who are you?
I am the daughter of that. My lord. I am the daughter, one of the daughters. There are two daughters. I am one of the daughters. Yes.
And who gave this will?
Will has been given to the son, my lord. The son claimed for probate.
And you are the son.
Yes, yes. I am the daughter.
As per this, what has happened?
Asim Ford is the beneficiary of the will.
What is the name of the son?
Asim Ford. Asim Ford. Asim Ford. I appoint Asim Ford as the sole executor under this will. The bigger question is that, my lord, the application of Article 136. It is from the right to apply accused or but from the date of knowledge as they are saying. These are the instructions.
And how does Tariq come into the scene?
My lord, he is one of the advocates. He wants to say that it has been given to him. Therefore, someone can.
Now, how can it be given to him? Huh?
Must have been the last part of 2019. I had got knowledge about this with.
No, how did you get it? Because you see, you are the executor.
Yes, sir.
If you are the executor, you don't know about the will.
I have filed.
You are the beneficiary also.
Okay, beneficiary is my wife. I am the sole executor. Our son and
So so your mother-in-law gave all property to the
daughter-in-law.
daughter. And who are these? Deepak Kumar Bhuya?
They are the witness lordship. Because I have filed an RT application lordship, whether the thief was-
No. How did you know that there was a requirement of a RTI application?
because I have no copy lordship. I have no copy with me.
Understood very well. But how did you file? Why did you have to after so many years? There has to be some reasonable grounds.
Lordship, read the story. It's very interesting. Just look for a moment.
What is it?
Lordship, it start from page 24. Page
Hello.
28.
We allow Mr. as application. This is not done
Lordship, may
on
kindly,
the page.
I have the judgment of the Supreme Court, Lordship, 2020.
Which one?
2020, Lordship.
What
12
does it say?
STC, 480. Samir Kapoor and another versus State Pro Subdivision Magistrate.
2020?
2020, 12 STC, Lordship, 480. Page 16. Page 480.
2020.
Same 12.
4 STC.
2020, 12 STC, 480. Sir. Yes. Okay, may kindly come to paragraph 16.2. Lord. Samir Kapoor and another.
Yes.
Lordship, kindly come to paragraph 16.2, Lordship. In the aforesaid decision, the court also considered and referred at STC page 468, para 15, the para 16 of the decision of the Bombay High Court in Vasudev Daulat Ram, so and so in para 15, which reads as follows. Rejecting under the Limitation Act, no period is advisedly prescribed within which an application for probate, letters and administration of succession certificate must be read.
Lordship, kindly come to B, Lordship. The right to apply would accrue when it becomes necessary to apply, which may not be necessary be within 3 years from the date of the deceased death. Delay beyond 3 years after the deceased death would arouse suspicion, and greater the delay, greater would be the suspicion. Such delay must be explained, but cannot be equated with the absolute bar of limitation. Once execution and attestation are proved, suspicion of delay no longer operates. In this case, Lordship, I, along with the petition Lordship, also file an affidavit Lordship, by the attesting witness Lordship. Uh, 15, 16 also.
See, this is Bombay judgment. Whereas 16.2 is a Bombay judgment.
Yes, sir. The Supreme Court has
This court did not agree with the above conclusion B.
only B in regard to B Lordship.
However, approved conclusion C.
Reproduce here and above.
What is conclusion B? The assumption under Article 137, the right to apply necessarily accrues on the date of the death of the deceased is unwarranted. So, what does the court say? This court did not agree with approved conclusion B. Meaning that what? Did not agree to.
I have already the delay it only creates suspicion Lordship. Otherwise, also not a matter of principle in such a succession case. That is point.
No, the question is, I think, you are not getting the right judgment. The judgment which says on Article 137 is when the right to apply accrues.
Yes.
Right to apply accrue on various circumstances.
Yes.
It is not on the question of death. There is one judgment of Justice Chandrachud. I think, is this the judgment?
Next judgment, that Manoj Justice Chandrachud judgment I have given.
Where?
Interpretation of 137.
Yes. Where is that?
Manoj, this is recent.
Yes, this one.
The paragraph is Manoj, 20,
Wherein it says 137 is a different, how it is to be.
Page 26.
Page
26. Middle part.
Since none of these articles in limited provide a period for a limitation and remand, it would be covered by the residual provision under 137, which provides the period is 3 years from any application for which no period of name is provided elsewhere. The time limit are from the period where the right to apply accrues. Then where it held,
yes,
the rate, sometimes the right to apply may not accrue.
Yes,
just for example, the sisters and the brother out here had no problem out there. They may not. So they have no. So you cannot say when the right to apply accrues. The applying accrue will happen on certain circumstances.
I have got the knowledge in the last part of 2019. No. Right to accrue operates from
No, not on the basis of knowledge. See, that is, if you are saying about the right to knowledge, why did you file the Limitation Act at all? Who has asked you to file?
1443. There is no reason. Now, Lordship has pointed out a very good judgment, my lord. That is a principle Lordship has laid down. 2022 judgment, where two paragraphs are reported.
Does not go to my judgment. Yeah. Where does the Supreme Court say here? How does the right to accrue?
Yes, my lord. That paragraph. My lord, page 26, the part of the paragraph 47.
No. In this case, it categorically held what does the right to accrue.
My lord, Lordship can is see page 26 from bottom third paragraph. The line start from since none of the article is scheduled out to the
No, that I read it. But what does it mean by right to apply accrues? There is
last line. The time limit starts from the period when the right to apply accrues.
That I know.
Yes, ma'am. Yes,
I'm asking you.
Yes.
Understood.
The Supreme
Thank you.
Court categorically observed what is right to apply cruise.
That is also
There's a
there.
judgment, categorical judgment.
Yes.
I think, is this the case of court?
Thank you. But Lordship has rightly held that because of circumstances and each and every facts are different from. That is the ultimate crux of that method.
It's a very long judgment. This
Yes,
is a
sir.
short one.
I have also gone through my that now my eyes are.
This is the my other judgment is on a question of delay. But
Yes,
I
sir.
don't understand where is the question of delay.
While considering the limitation, Lordship has pointed out two principles which is very important.
Hmm.
That is very important. Paragraph 19, my lord, page 41 per book. I would like to derive on. Lordship has not only concerned about the sufficient cause, it has been expanded to another zone, my lord. That is, after showing sufficient cause and obligation is cast upon the court, whether in this case it should confirm the petition.
No, understood. But by filing an application, did you say that this is being done as a matter of abandoned caution?
Yes, Lord.
Have you mentioned it in your application? No.
I have not mentioned, Lord.
So then, if you have not done it as a matter of abandoned caution, then are you not admitting that there is a delay?
There is a delay, Lord.
Which means your right to accrue arose 1463 days before. You see, right to apply accrues, these are not the judgment, there is a categorical judgment wherein it says it shall only apply at the time when it is required. And as such, it says, although there is one judgment of our Justice Ansari's judgment, I think the matter went to Supreme Court. Yes, Mr. Arnab Biswas. There was one judgment of Justice Ansari. Yes, what happened there? It held that 3 years from the date of death.
Common judgment I have seen. Ultimately, date of death is the right to access. It's the basic knowledge nowhere, my lord. I have that knowledge may be a part of limitation, but it's to be counted from the date of death. The period to start there. Others they have applied this principle, but wrongly, my lord. They are contradictory state in their part. They want to say.
No, just for example, it's okay. They may have, but they can still file an application under Section 5 and explain the delay,
Yes.
which they have done. Now, here I am concerned with as to whether the explanation was right or wrong. They say that they did not know the one fine morning they woke up and went to the here to find out, and then some Tariq fellow gave him.
Yes.
And Tariq has nothing to do with this deed. The will has nowhere mentioned about anything about Tariq.
Witness is someone else, my lord. Advocate witness is someone else. Otherwise,
It's some Gautam Chakraborty.
I have applied the RTA Lordship through this Tariq advocate. He has supplied me the.
This is a registered will.
Yes, the registered will.
Otherwise, the public.
Lordship, may kindly come to page 28, Lordship. Paragraph.
No. There is one judgment categorically. If a document is registered, then the will's period will start from the date of death. It's deemed to be known.
Lordship, may kindly come to page 28.
It's a second question. This
Page 28, Lordship. My delay petition.
Page
28, Lordship. My delay petition. Paragraph 3. That the petitioner said that he had no any earlier knowledge of the will of late Parul Pala Paul, who was his mother. Sometime in the last part of year 2019, the petitioner from some reliable source came to know that late Parul Pala Paul had left him with. Having so learned, the petitioner had made an application to the Public Information Officer in Sukia under the Right of Information Act 2005, seeking for information as to whether late Parul Pala had registered any will in the office. The said application has been forwarded to the IC, Senior Sub Registrar in Sukia by Office Memo Number so and so, dated
11 to 2020. Replying to the state application, Senior Sub Registry Office Tinsukia confirmed the existence of the will of late Parul Pala registered on 21/7/2013 and supplied a copy to the same being collected by the applicant's lawyer.
This line is very important.
And the state lawyer
Applicant's
handed
lawyer,
over to the copy of the will to the applicant on 25/9/2020. The original copy of the same, however, reported to have been collected by the Parul Pala's engaged advocate sometime after his registration. The petitioner has thus
Where is your document? A copy of the letter issued from the office of the AR bearing number is annexure 1.
they have filed the petition. They have filed this petition. They have annexed it.
Now, Lordship, only one line is very important. Applicant's advocate matter. Lordship, this line is very mind-soaking. By the applicant's lawyer, he collects applicant. He himself engaged his own lawyer. He collected the
Lordship,
copy.
may kind of next para, Lordship.
He lawyer collected the copy in 2013 for a moment, and he's sitting over, and there is no any communication with his own lawyer, my lord. Can it be relied upon?
Therefore, the petitioner has
It's a
thus
complicated story, my lord.
When did the lawyer get it?
on 25/9/2020. It was handed over to me, Lord.
This is the date of
Because
law.
I have applied this from my advocate, Lordship.
No, that is not line. Lordship, line is very much clear. Lordship, can you confirm the existence of the will of late brother registered and supplied a copy of the same being collected by the applicant's lawyer, and the state lawyer had handed over the copy of the will to the applicant.
After that, I have sent some registered post notice, Lordship, to the attesting witness. They have come and handed over me the original will, Lordship. After that, I have filed this petition with a delay conversation.
This is an application under Article 115 or
My lord, it's not one.
227?
Yes, 225.
227 of the Constitution of India, challenging the order dated 2/5/2023 passed in Mizze case number 04/2023, whereby the learned district judge Tinsukia had condoned the delay of 1443 days in filing the probate application. It is relevant to take note of that the mother of the mother of the petitioner, as well as the respondent herein. Your petitioners, na?
Yes.
One or two?
One.
Of the petitioner as well as the respondent herein. One Parul Bala Paul had executed a will on 15/3/2001. One, na?
Will is, my lord, 21.
21/11/2013.
13.
Huh?
21/11/2013.
21/11/2013. There's no date of the will.
Yes.
Where?
At page 18.
Yes.
Page 18.
Yes, where?
I don't stop.
Yeah.
21/11/2013. The
No,
date
this
of-
is a registration.
Yes.
You see, a will can be registered and maybe
Yes, yes.
later on also.
But the will date, my lord,
Will date 21/11/2013, Lord.
Huh?
Registered on 21/11/2013.
No, registered, you see, a will can be registered even after the death also. Isn't that the special provision under section 41? But it doesn't say so 13, na?
the registered part.
There's no date in the will.
Date is also not there. No, it's a deal. It's totally suspicious. I am the daughter. I do not know anything about this thing, my lord. And suddenly,
Had executed the will.
that's it.
You said purported.
Purported.
Purported will.
Alleged.
Just mention, Lordship. Registered.
Which has been shown to be registered on 21/11/2013. In terms with the said purported will, the respondent herein was appointed as the sole executor and who was directed to obtain the probate from the competent court of law after the death of the testator. It is very relevant to take note of that the said will, that from the contents of the said purported will, it is seen that one Gautam Chakraborty advocate had prepared it. Full stop. After a passage of almost 8 years, an application was filed under Section 372 of the Indian Succession Act 1925, seeking grant of the probate in respect to the said purported will by the respondent. Along with the said application, another application was filed under Section 5 of the Limitation Act 1963, thereby admitting that there was a delay of 1443 days in filing the probate petition. The reason assigned in the said application is that the respondent had no knowledge about the will, about the purported will of his mother, and only sometime in the year 2019 he could come to learn from reliable sources that his mother had left a will for which the respondent made an application to the Public Information Officer Tinsukia under the Right to Information Act 2005, and it was informed by the communication dated 11/2/2020, was informed by a communication by the informed that there is an existence of the purported will dated 21/11/2013, and a copy of the same was handed over to the respondent on 25/9/2021. It is under such circumstances there was a delay in filing the probate application, which was filed on 15/3/2021. 15/3, na?
Yes, sir. 53 third.
Full stop. The petitioners herein filed objections against the condonation application stating inter alia thereby denying the contents of the application. This court had heard Mr. S. Samaria, the learned counsel, appearing on behalf of the applicant, petitioners, and Mr. D.K. Kolita,
Yes, sir.
appearing on behalf of the respondent, and they have duly taken note of their respective submissions. The law is no longer res intriga that for the purpose of seeking probate of a will, the provision, the limitation, there being no specific period of limitation assigned by the Limitation Act 1963. The provisions of Article 137 of the schedule to the Limitation Act 1963 shall apply. From a perusal of the said Article 137, it reveals that the period of 3 years shall be reckoned when the right to apply accrues. In opinion of this court, the right to apply is a dynamic concept depending on the facts of each case. In the instant case, late Parul Baladas Paul had expired on 21/3/2014. It is claimed by the respondent herein that he had no knowledge about the will till he received some reliable information from some person that his mother had executed a will. The lack of particulars as from whom such information was received is an aspect which ought to have been mentioned by the petitioner and respondent. Taking into account that the said is a very material fact which ought to have been stated. This court have also perused the will which have been enclosed to the instant application. From the said will, it is seen that the petitioner and the respondent herein have been made the executor, sole executor of the will. The address of the testator is the same address of the respondent. There is no mention in the application as to how the attesting witnesses are related or connected with the mother of the with the testator. These aspects are very vital, taking into account that the testator was 74 years as stated in the will when the will was purportedly executed. Her residence is that of the residence of the respondent. The attesting witnesses reside at a different locality from that of the locality wherein the testator and the respondent resides. Under such circumstances, it becomes unbelievable unless some material facts are being brought in as to how the respondent herein was completely unaware about the said will. There is no mention in the application as regard any circumstances by which the right to apply got delayed. Inasmuch as there may have been circumstances wherein the parties may have earlier, the legal heirs of legal representatives of the testator may have earlier agreed to a settlement which now they do not agree. For which it has now become necessary to apply. The story which the basis on which the instant application is being filed is that the respondent was completely unaware about the execution of the will. The learned court of the district judge condoned the delay without taking into consideration these vital aspects of the matter, which very much touches on the explanation as regards sufficient cause. In a recent judgment of the Supreme Court in the case of Probate 2024, the Supreme Court categorically observed as regards Section 3 and Section 5 of the Limitation Act 1963 and opined that Section 3 has to be strictly construed, whereas Section 5 has to be liberally. The Supreme Court further observed that even in a case where sufficient cause has been shown, then also, if there is a case of lack of negligence, the court may not condone the delay. In the instant case, the non-disclosure of the vital fact as to how and from whom the respondent got the information in the year 2019 about the execution of the deed of the purported will renders the remaining explanation redundant, which the learned trial court failed to observe. Under such circumstances, it is the opinion of this court that the learned trial court has exercised the jurisdiction, have committed a jurisdictional error for which the impugned order dated 2/5/2023, passed in Mizze case number 04/2023, is interfered with. Conclusion. Consequently, the application would be barred by limitation. Application seeking probate would be barred by limitation. And the said probate application therefore cannot be entertained. with the above the instant proceedings as disposed.
Always. But for all our questions relating to the cross-examination of the defendant, that's me. And till date, no issue has been framed.
Not necessary.
And it is necessary that whether starting this question which has been sought for.
No, those questions
Yes.
have any relation with your defense.
Yes, kindly see that question.
That's all.
Yes.
Only thing in inquiry is that.
And for that order, Rule 21, 20 and 21 was not followed.
No, this is an order passed on the order 11 rule 20.
1,
20.
not 21, 1.
No.
Yes.
They filed an application under
Application
order
under
11 rule 1. If you don't answer to that, then they will go under order 11 rule 21.
Yes.
When-
Now kindly see the interrogatory has been sought for. Page 42.
Page
42.
40.
4.
Yes.
Whether the reference to statement made in paragraph 5 of the joint written statement of defendant number 1 and 2, the plaintiff petitioner seeks answers from the state defendant as to exactly on what date the state defendant have come to know about the partition family arrangement dated 10/1/2018 made between the sum of the years of Himara leave, and as to whether the defendant number 1 and 2 were affected in any way by the state partition, and if so, in what manner and way they have been affected, as to whether they have sought any legal relief against such partition till today. The separate suit is pending with respect to that. If any legal, next question, if any legal relief has been sought for, in what manner and in what way, and in which legal forum such relief has been sought for, specifying the number of the case suit, if any, and the name and designation and forum from which such relief has been sought. On what basis the defendant number 1 and 2 in paragraph 5 of their joint written statement has claimed that the sale deed of the suit land by the defendant number 3, 4, 5, 6.
No, first and foremost, tell me whether this application which was filed was preceded by an interrogatory.
No.
I filed the application along with
the person who has filed the interrogatory, it is defendant number 1 and 2. But from the record, I found that no leave as per order 11 had been sought for prior to starting of.
No, before you are asking an order under order 11 to them.
Rule 1. Order 11 of.
You are asking an order under order 11 rule 11. In respect of an interrogatory made under order 1 rule 1, order 11 rule 1. Now first you are to give your interrogatories to him. If he omits to answer, then only you can come to the court.
My lord, I filed the application under order 11 rule 1, seeking leave to file interrogatory. Seeking leave.
But why did the court answer, direct them to
My lord,
answer?
court, they objected, saying objection is here, saying that issues have not yet been framed, so this cannot be adjudicated.
That cannot be a ground. You
That
can ask the interrogatory even before.
yes.
The
And
moment a written statement is filed, you
yes. And
but
the court allowed leave of the appeal order may be seen, my lord. The court has allowed at page 53, 25/7/23 order is there.
no, understood. The court can grant leave under order 11 rule 1.
Yes.
But if they leave after being granted, if they don't answer, you have to move under order 11 rule 11.
Yes.
Now, why did the court ask them to answer? Finally, see order 11 rule 11.
Yes.
Where any person interrogated omits to answer or
Yes.
answers insufficiently, the party interrogating may apply to the court for an order requiring him to answer or to answer further, as the case may be. And an order may be made requiring him to answer or answer further, either by affidavit or by verbal examination.
Yes.
Because when you ask under order 11 rule 1,
What?
you are to give it in a particular form, form 2. Form 2 in appendix C.
Correct.
Then they are going to reply in form 3 in appendix C, which is not on affidavit. Now, if they don't answer, then you can move under order 11 rule 11. But why did the court direct them to answer when you are asking only the leave?
Yes. I paid for leave only.
You are right.
Yes.
But the question is that the trial court made a mistake.
Yes. They have not objected to any of the interrogatories.
They have not answered it.
Yes.
They have to answer it within a particular period, is there?
Yes.
What is the period? Period of 4 days is there, no?
One thing for judgment, my lord, regarding interrogatory, my lord, questions that may be relevant during cross-examination are not necessarily relevant as interrogatory. The only questions that are relevant is in interrogatory are those relating to any matter in question. The interrogatories are on or have reasonably close connection with the matter in question. Viewed thus, interrogatory number 20 must be held irrelevant.
No,
So
that,
here in
for
this
that,
question-
no, for that. When you don't answer, you may very well answer to him and saying that this is
Then,
not relevant.
This is for the purpose of cross-examination, I may say.
You may not say for the purpose of cross-examination. You may say that this is not relevant.
Relevant.
But you have to answer. If you don't answer,
And-
then he has a right.
And when he has filed application before the court, I have made objection that it is irrelevant.
You cannot. Where is the scope of filing an objection at the time of seeking leave?
No.
Even
Kindly
Mr.
see
Ghosh, even you may not seek, you can give the interrogatories also.
Kindly see application, my lord. Yes, 41.
In any suit, the plaintiff or heir by leave of the court may deliver interrogatories in writing for examination of the heir or any other person, or interrogatories when delivered shall have a note at the foot stating at which time of such is required to answer. See, you may ask, he may ask for leave. Without leave also he can give it to you.
Here it is petition, he seeks leave. But the court directed to give the answer.
Okay? The court made that mistake. You have to answer, then he has to go. Okay. Now, this is an application under Article 227 of the Constitution, challenging the order dated 25/7/2023, passing statute number 27/2022, whereby the learned trial court, that is the court of the civil judge, Halakan, had in an application filed under order 11 rule 1 seeking leave to deliver interrogative, have not only granted the leave but also directed the defendant to answer to the interrogator. In the opinion of this court, the same does not seem to be in accordance with the provisions of order 11 rule 1 for 1/4 6 9, and 10 of the Code of Civil Procedure. Inasmuch as it is only when the defendant or it is only when the party refuses to answer, omits to answer, or answers insufficiently, then an application can be filed under Order 11, Rule 11 of the Court to the court for an order requiring the party interrogated to answer or to answer further, as the case may be. In the instant case, at the time of seeking leave, the learned trial court directed the defendant number 1 and 2 to file their answers to the interrogatory positively by the next date. Accordingly, this court therefore only interferes with the order dated 25/7/2023 insofar as the direction issued to the defendant number 1 and 2 to file their answers to the interrogative positively by the next date. However, this court does not interfere with the rest of the order wherein there is a direction wherein leave has been granted to the plaintiff in terms with the application under Order 11, Rule 1. Considering the above, this court therefore disposes of the instant writ petition by observing that the order dated 25/7/2023 passed by the learned trial court to be an order by which leave had been granted to the plaintiff to deliver the interrogatories to the defendant number 1 and 2. And it shall be within the and the defendant shall thereupon exercise their rights as envisaged in Orders 11, Rule 6, 7, 8, 9, and 10, if so advised. It is made clear that in the circumstance, the plaintiff is dissatisfied with the answer so given to the interrogatory so made or requires further answer, the plaintiff would be at liberty to file application under Order 11, Rule 11 of the court. This court further takes note of that by the order dated 28/8/2023, for further proceedings of title suit number 27/2022 was stayed. This order stands vacated and the parties are directed to appear before the learned trial court on 5th of June 2024. On or before the said date, the respondent, the defendant, the petitioner herein, who are the defendants number 1 and 2 in the suit, shall exercise their rights as stated herein above in terms with Order 11, Rule 6, 7, 8, 9, and 10, if so advised.
Forty-three.
Yes, what are you challenging?
I am the defendant number 10, my.
Hmm.
If my friend is the plaintiff, my plaintiff filed a suit for right title interest, my.
Hmm.
Thereafter, I filed written statement, my.
Hmm.
Thereafter, after initial stage, the plaintiff filed a amendment petition, my.
Hmm.
That amended allowed my law. Thereafter, I filed the amended written statement, my.
Hmm.
As directed by the owner. But at the time of filing amended additional retail statement, additional word is not.
So, how does it matter?
Invariably failed, the petitioner failed to write the word.
Where, which order? Yes, Mr. Bora?
No, actually, he has
It is
projected
my lord.
not the real story.
Okay.
Actually, what is plaintiff has filed suit for declaration of right title interest, confirmation position, and permanent injunction. Accordingly, after receipt of notice and summon, my learned friend as defendant number 10 has appeared and filed his WS cum counterclaim.
Hmm.
And thereafter, the present respondent plaintiff filed an application under order 6 to 17
Hmm.
for amendment of the plain
Hmm.
for inserting of the power of attorney. Earlier power of attorney has revoked and subsequently plaintiff engaged in new set of power of attorney. And that must for inserting in the plan, original plan by way of amendment.
Hmm.
Subsequently, my learned friend as defendant filed an same WS cum counterclaim before this trial court. That was rejected. This is the case. Amendment thought for only for inserting new set of power of attorney. Here is the record.
Where?
Kindly SP.
Today is the date fixed for filing additional written statement by defendant number 4, 5, 6, and 10 against the amended claim. However, instead of filing the additional WS, has filed fresh WS, some counterclaim against the amended claim. Record says that the REA had already filed, so and as such, WS some counterclaim filed by today is accepted and not taken on board. Yes, what you wanted to file what?
Additional written statement counterclaim method only.
Why a counterclaim again?
Because
No, you can, Mr. Saikia, what is a counterclaim?
Counterclaim minor right title interest.
Understood. You have already filed?
Yes, my.
Isn't the counterclaim a suit?
Yes, my lord.
Then how can you file another one?
Not another one, my
Did
lord.
you pay the court fee again?
No, my lord.
Then
Not 40. Only additional word is mistake, my lord. Mistake.
no, Mr. Saikia, kindly understand one thing. When he seeks an amendment, you have to file an additional written statement. So when you file that additional written statement out there, you are only to deal with by relying on your earlier counterclaim or written statement,
Yes.
only to that paragraph which have been done. You don't need to repeat again.
I am not, because
What?
If-
Show me your additional written
Yes.
statement. Yeah. Where? Which has been rejected?
85, my lord. Additional, original 34, my lord.
Additionally, yeah. Then?
Original 35, page connected.
Yeah.
And
Then what are you asking for?
Minus 85.
Huh?
85 P.
Show me the earlier one.
Earlier one is my lord 34. Page 34 and XRP, my lord. Here is also fake, my lord.
Wait. Which is the paragraph which was amended
No, kindly.
in the plain?
My lord, kindly page 46, the application for amendment. Page 48, internal page, para 6. Start amendment application. 48 page of 48, para 6.
That is the only para 6, nothing more.
Nothing more.
But
Only
why are you
names
filing
of
this
the-
type of application? This is an order 1 rule 10.
Yes, my lord.
No, by way, this is the application.
Isn't this an order 1 rule 10
No,
application?
Yes,
Effective.
no, both provision has been putting.
Okay, very well. So now you want to implead 2 plaintiffs
Yes,
instead of plaintiff number 4.
earlier.
That is it.
Yes.
Now what he has done,
There is nothing to filing any additional. How he has approached before the normal court is unnecessary time taking.
we will impose cost, don't worry. Yes,
My lord.
there's
Page
nothing,
28, my
there's
lord.
nothing else.
My lord,
You may say, where is your reply?
my lord. Page
No, where is your reply to the
21, my lord.
amendment?
Because he amendment was plain on the impleting 4 and 5, my lord, instead of 4. But he changed the pleading in environment in the plain, my lord.
Where?
And prayer also changed, my lord.
Where?
Without leave to the court, my lord.
So then you oppose that.
Yes, my lord. That is why I am filing the additional retachment.
It is the moment you are filing the additional written statement, yes, it can be done. You can very well file an additional written, but how can you file an additional counterclaim? Your counterclaim is already there.
Yes.
You see, counterclaim is like a plaint.
Yes.
Now, just for example, he has now, in order to change his plaint, plaintiff number 4
Yes.
to 4 and 5,
4 and 5.
what did he do? What did he do?
He changed the
He filed an application for amendment.
amendment.
Now,
And-
are you filing an application for amendment of the counterclaim or not?
No, my lord.
Can there be 2 plaints? No. There has to be only 1 plaint. There will be either a plaint or an amended plaint. What you have done? First counterclaim, again another counterclaim. It's not permissible.
It's not another, my lord, because the leading apartment, my lord, entirely changed. Prayer also changed.
I will allow you. Okay.
My lord.
Okay, I allow you.
Well-
How much court fee you paid the earlier one?
Prayer also changed, my
No,
lord,
no.
amended plan.
That you oppose.
Amendment not allowed, my lord. That is why.
So you oppose.
Yes, my lord. I will oppose, my lord.
Then why you are filing this?
Because by the additional counterclaim, additional word is only left out, my lord.
But how can there be 2 counterclaims?
I have not filed, no court fee has been filed, my lord.
So what? Now you pay. You pay the additional court fee, 11,000. Na?
Yes.
Again, you pay another 11,000. You want that? Then? Goodness. Leho. It is actually what has happened. This is actually the laziness on your part. You didn't want to do anything. Again, you wanted to file another one, the same thing. You didn't change the earlier one. Did you change the earlier one?
No.
Then, why did you
Okay,
file it again?
Only is the amended plan, my.
Heard Mr. Executor, the learned counsel appearing on behalf of the petitioner, and Mr. L.K. Bora appearing on behalf of the respondent. This is an application under Article 227 of the Constitution challenging the order dated 18/7/2023, whereby it has been alleged that the learned trial court refused to accept the additional written statement cum counterclaim which was filed on 18/7/2023 on the ground that the defendant number 10 had already filed the written statement cum counterclaim on 2/8/2022. This court inquired with the learned counsel appearing on behalf of the respondent, who is the counsel also for the plaintiff, as to what amendment has been sought for. The learned counsel submits that in view of the respondent number, the plaintiff number 4 having given a power of attorney to 2 persons.
4 and 5.
2 persons.
Yes.
An application was filed thereby application was filed in terms with Order 6, Rule 17, read with Order 1, Rule 10, for the purpose of striking out the name of the existing plaintiff number 4 and substituting him by
two persons who's as plaintiff number 4 and 5. This application was allowed. On the other hand, if this court duly takes note of the submission of Mr. S. Saikia, the learned counsel appearing on behalf of the petitioner, who submits that the amendment plain, although the amendment was only sought for the purpose of substituting the original plaintiff number 4 by the newly inserted plaintiff number 4 and 5, but there has been various other amendments made to the contents of the plain without even taking the leave. It has therefore become necessary for the defendant number 10, who is the petitioner herein, to file the additional written statement. This court, however, takes note of that the counterclaim was filed on 2/8/2022 by the defendant number 10. The counterclaim is like a plaint by itself. And as such, there cannot be filing of two counterclaims unless the earlier counterclaim is amended. The only liberty which was granted to the plaintiff, to the defendant number 10, by the learned trial court was to file an additional written statement, meaning thereby that as regards the amendment which have taken place, the plaintiff, the defendant number 10, would have the liberty to do so to state its defense. However, what is noticed out here is that the plaintiff, that the defendant number 10, who is the petitioner herein, again filed the same set of written statement counterclaim, which was already filed on 2/8/2022. The same, in the opinion of this court, was an error on the part of the counsel. And as such, in the opinion for which this court for the interest of justice permits the defendant number 10, thereby granting him time till 19th of June 2024 to file an additional written statement to the counterclaim, to the amended claim. It is further mentioned herein that there cannot be a counterclaim filed with the additional written statement, inasmuch as the said counterclaim had already been filed. Taking into account both the parties are duly represented in the matter, this court directs the parties to appear before the learned trial court on 19th of June 2024, on which date the defendant number 10 is given the liberty to file the additional written statement in terms with the observations made here in the above. My goodness.
LCR receipt that may be sent back.
Huh?
LCR.
LCR has been received. LCR can immediate copy. And good stuff. In addition to that, the defendant number 10 shall be also at liberty to file objection before the learned trial court if the plaintiff have carried out any amendment to the claim beyond what was allowed by the application, by the order permitting the amendment of the claim on that same date.
Right.
Yes. EVK. Where is Mr. K. A. Majumdar? Stay is there. How can there be a stay to DV case? Why? What has happened, Mr. Hussain? Tell me,
If your lordship,
which order he is challenging?
getting the order of issuance of summons, not any order. Only
Huh?
summons was issued to the petitioners.
What?
Only summons were issued to the petitioner. He has challenged the summons,
Why?
saying that he does not fall under domestic relationship and as such, no case would be live against the petitioner.
None appears on behalf of the petitioner on call. Mr. M. Hussain appears on
MH
behalf.
law- MH law.
M.H. Loskar appears on behalf of the respondent. For the ends of justice, the matter stands adjourned to be listed again on 29th of May 2024. It is made clear that if on the next day the petitioner is not represented, the instant petition gets dismissed from execution.
Okay.
Yes, what happened?
My lord, with regard to the trespass,
Service complete.
service complete. If I had done the and of that, so if with the metaverse court,
Hmm?
the metaverse court, family court also, the response represented there, it is honorable court informed the respective person, the matter is.
Then you are both of you are appearing in spite of a stay.
No, my lord, because the stay is.
Or there is no
continuing.
stay.
My lord, there is stay, but the dates are.
Huh?
Dates are given when people got presenting the stay or the court.
Frequently. Okay.
From after we are submitting the order. I don't think regard to this. For the
Does the court record that the respondent was present in the orders?
was presented at the court.
List the matter. When is the next date in the
24.
24th June? Okay. List the matter again on 27th of June 2024. It has been duly informed by the learned counsel appearing on behalf of the petitioner that the matter before the learned trial court is fixed on 24th of June 2024. This court requests the learned trial court to intimate the respondent about the pendency of the instant writ petition of the transfer petition and the orders passed herein, which the counsel for the petitioner shall duly produce before the learned trial court, and the same be recorded as to whether the same have been intimated to the respondent herein by the learned trial court. On the next date, the order dated 24/6/2024 be produced before this court.
I got can
Interim
we
order
not
passed earlier shall continue till the next.
I got we may not get it.
What?
We did not get the certificate of the past. Can it be
I'm having it on 27. How much time does it take?
don't get it?
Don't get a certified copy. Ask the court to give you a certified copy.
Okay.
It is only for the purpose to know as to whether they have known or not. Once it is being recorded, then I will take it.
Must of that.
Is it? Taking into account that the service have not yet been effected upon the respondent. The matter stands adjourned to be listed again on 21st of June 2024. Interim order passed earlier shall continue. Yes, such an old matter.
Lordship, I am for respondent number 1 on behalf of Matni Aarti.
Chalo. What is this? Who filed the appeal?
Claimant filed the appeal for enhancement.
Chitra Sinha.
On the last two occasions, they remain absent on call.
What is this appeal for? Enhancement.
Enhancement.
Why? How much? So the claimant shall get compensation of rupees 2,21,000. How much is she asking for?
As per claimant version, the monthly income was rupees 8,000.
Then how much did the trial court hold it? 3,000. 3,000. This is prior to Pranay.
I have to go through.
What proof was there?
They orally submitted.
None appears on behalf of the appellant on court. It is seen, Mr.
Yeah, that.
So appears for the old respondent.
Respondent number 1.
It is seen that the counsel for the appellant had not represented on various earlier occasions also. This is a matter of 2014. And in view of non-appearance earlier, the instant appeal was dismissed on 7/2/2020. Subsequently, it was again restored on 7/9/2022. Even thereafter also, the appellant is not being represented on 10/11/2023, 12/1/2024. From the above, therefore, it reveals that the appellant have lost interest in the matter for which the instant appeal stands dismissed for non-prosecution. Who? Who is the petitioner? He has filed affidavit on stating he is no longer active with the affidavit. Now you are appearing for whom? Esther Gogo is no longer there. Ask them to submit. Then what do you have to say? By the order dated 12/11/2021, this court has directed the respondent and the registry to issue notice to the petitioner. It is seen that on 18/11/2021, notice was issued to the petitioner. However, it is not known as to whether the said notice was received. Taking into account the registry is directed to intimate this court hey, মোক এটা বস্তু চাই দিয়ক টাইটেল 247/2005 Munsif number 1 Nogao. Is it pending? I think it is no longer pending. Nobody is bothered. They gain some injunction order. 47/2005. That is good. Just find out, let me know. Dismiss it if the truth is known.
Well, here actually the matter was put a court below.
You file an IA?
Lordship, that has been disposed of. Now, Lordship, after a long time, a talk of compromise is going on. So the families are trying to sort it out. So we have in view of that compromise being going on, Lordship, I'm praying for some time, 2 weeks time. After a long time, they're in talking terms. Mr. Anil Agarwal, he is quite sick now. So I have been instructed. I have got a letter yesterday, Lordship. So I may kindly share with you, Lord.
This is what matter?
This was a partition suit, Lordship, which was going on in the court below.
Then
Judgment was pronounced, and in the judgment, Lordship, one of the parties expired, Kamla Devi Agarwal. Now, in place of late Kamla Devi, the name of late Bimla Devi was written down. That just for changing that part of petition was, but it was disallowed. So it was an inadvertent mistake in our part, fairly speaking. It is there in page number 36.
you filed a 152 application.
Yes, Lord, for amendment of the judgment.
Amendment of the
Judgment. The judgment was already pronounced. In the judgment, what happened? Inadvertently, the name in place of name late Kamla Devi, late Bimla Devi came up. That means in place of.
Why didn't the court do it?
Court said that since there was no mistake in the part of the court, the mistake was in the part of the petitioner.
You must have put it Bimla Devi out there. Then you have to amend your plain.
No, not in the plain. In a petition subsequent. In a petition subsequent, in number of petition, in one petition, in the plain it was all right, because
Anyway, at the request of Mr. Eberchetri, matter stands adjourned. Sign it there. Matter stands adjourned. Sign it there. Is there any stay?
No, there is no.
Matter stands adjourned. Sign it there to be listed as and when the matter is mentioned. Matter stands adjourned for 6 months. Yes, what is this?
I am appearing for
13. Unserved notice or AD card of so and so have not been arrived.
I am for respondent number 1, my.
You are appearing. Yes, what happened?
But the service not complete.
2016 matter service is not complete for what? This is for what? Condonation. Huh? 80 days condonation. You are not bothered. Give me a good reason why I should not dismiss it.
In one order, there was presentation.
Huh? It's a case of sheer negligence on the part of the lawyer. You can't serve a person for 8 long years. What is there in this matter? 80 days delay.
But
Lordship may period order dated 6/6/18.
What?
Order dated 6/6/18.
6/6/18.
There was representation.
Then M. Mazumdar Learned Counsel appearing for the private response number who sought for 1 week time to file objection. Okay. Now you are appearing for whom?
Respondent number 1.
Huh?
Respondent number 1.
1 to 6?
No, 1, only 1.
Okay. And what is this I? Again unnecessarily no. 80 days delay. We condone it. This is an application for condonation of delay of 80 days in preparing the accompanying appeal against the judgment and decree dated
Judgment
31/3/2015 passed in title appeal number 8/2013 by the court of the
Laden.
civil judge Bongaigaon. Huh? Isn't it?
Yes, sir.
Appellate court is who?
Appellate court Lanet civil judge Bongaigaon.
By the civil judge Bongaigaon. The delay and the condonation of delay of 80 days. Huh? This court have duly perused the order sheet, which it shows that on the earlier occasion the respondent numbers 1 to 6 were duly represented. However, subsequently on account of miscommunication, again notice was issued. Taking into account the order dated 6/8/2018, this court deems that the service upon all the respondent numbers 1 to 6 are duly complete. I've heard Mr. C. Sharma, the learned counsel, appearing on behalf of the applicant, and Ms.
L. Sharma.
So appearing on behalf of the respondent number 1. None appears for the other respondents on call. This court have also perused the grounds which have been stated in the application for condoning the delay of 80 days. The grounds in the opinion of this court are sufficient for condoning the delay. Accordingly, the delay stands condoned. I stand closed. The registry is directed to register the accompanying appeal and list it in the stage of Order 41, Rule 11. Ms. Coenso's name may be shown as the counsel representing the respondent in the cause list post the registration of the appeal. Further to that, Mr. C. Sharma shall provide a copy of the memo of appeal to Ms. Coenso during the court by tomorrow.
Obliged.
None appears on behalf of the petitioner on call. This court have taken note of that this is an order, this is an application file challenging an order Yes, Mr. H. does. Do some social service because of the mistakes you keep on doing in the court. In this matter, you take a copy. You appear in this matter for other petitioner counsel is gone. Here is a case where the suit was dismissed on the day on which the defendant witness was present, but the defendant was because the plaintiff was not present. So the suit could not have been dismissed for default. And the trial court, the first appellate, to restore it. So you do one thing, take a copy of this court have taken note of that by order dated 12/11/2021, this court had directed the registry to issue notice upon the appellant petitioner. Taking into account that the respondent taking into account that the earlier set of counsels have withdrawn their power. Wakalatna. However, it is not known as to whether the service was duly meted out to the petitioner. This court had requested Mr. H. Das, the learned counsel, as to whether he would like to be an amicus in the matter, taking into account a substantive right of the petitioner is being duly affected. Mr. H. Das, the learned counsel, has submitted that he would agree to be the amicus in the matter. Accordingly, his known name may be shown as an amicus in the instant proceeding by the registry. A copy of the petition be also furnished to him by the registry. This court, in addition, directs the registry to issue notice upon the respondent number 1 at the cost of the registry. On the respondent number 1, so that the matter can be brought to a logical conclusion. List the matter on 22nd of July.
In this case, their service could not be affected.
2017 matter.
I have tried to Dusty also, this court ordered Dusty service. What
Then?
happened? The respondent perhaps shifted their office. The place that
You are who?
Lordship, in this matter, in the cause release, the PP account was shown lordship. Maybe some kind of mistake in the part.
Soliha, you are appealing for whom?
Lordship, I am for the prosecution because name was shown that may be omitted lordship. We are not the party in the matter, but in the cause release it is shown lordship.
Soliha, where Singh is no longer there?
no lordship. What happened after that lordship? I tried to Google from the cover. If you lordship is the order sheet, there is a paper lordship. So where the register address of the now it's different. So I tried to take steps that without order from the honorable court, I could not take that. I put the underline there lordship.
Then
Rukminika. But the original address was Ananda Kuti that near Judaring.
okay, Mr.
S. Chakraborty.
Chakraborty. the learned counsel appearing on behalf of the petitioner applicant submits that the address of the respondent has now changed to Rukminigaon, Dispur, Guwahati, 781006,
I've taken up from this company law board company.
as he could obtain from the website of the Ministry of Company Affairs, Corporate Affairs. He is therefore directed to take fresh steps upon the sole respondent, opposite party, within 7 days, list the matter again on 2nd of September 2024.
On this address,
In the new address.
Lots of in the causative maybe. Or
Mr.
maybe
So-and-so's name has been wrongly, Mr. So-and-so submits that his name has been wrongly removed.
open.
Even the service upon respond number 17 and 18.
My lord, we are not appearing in this case anymore. We have written to the petitioner, my lord.
No, file an affidavit. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that they are no longer representing the petition. So this court makes it clear that the counsel will have to file an affidavit bringing on record any document, bringing on record such documents or evidence to show that the petitioner have been duly intimated that they are no longer representing, and if so intimated when, list the matter after 4 weeks.
Hello.
Yes, what is
I'm not facing it.
Huh?
I'm facing.
Mr. S. Chauhan, the learned counsel appearing on behalf of the applicant submits that the applicant would not like to press the instant application. For what?
I thought one direction was there to produce original matter if they does not specify.
Instant application for what? I for?
For leave it.
Huh?
Leave matter.
The instant application. Taking leave to appeal.
Yes.
Leave to appeal against the judgment. Judgment dated? Leave to appeal for what? Hey, Consong,
Against the succession.
18.5
Huh? Mr. Escon, the learned counsel appearing on behalf of the applicant submits that the applicant is not interested in pressing the instant application.
18.5.
It is relevant to take note of that the instant application is an application seeking grant of leave to prepare the the accompanying testamentary appeal against the order dated 18/5/2013 passed in probate case number 185 of 2011 by the learned district judge Kamrup, Guwahati, thereby granting probate to the opposite parties. So, taking into account that the instant application seeking leave has been withdrawn, taking into account the submission of Mr. S. Chauhan, the instant application stands closed on withdrawn. As withdrawn. The consequential effect of the withdrawal of the instant application is that the accompanying testamentary appeal cannot be entertained.
What's my name?
Yes, give your name properly. I said,
High level.
Service of the substitute respondent 1 year, 1 year.
Service complete.
complete the third sentence of the expert hearing earlier.
Okay. Service complete. LCR received. Is the matter for hearing in its usual course. Service complete. Service complete. I for what?
For condonation, but
How much?
my lord, then I find the petition.
That means it is much less, much more.
Yes, no, my lord.
46.
Then I find the petition. It was 230 days. It was during.
Now it is 46 days.
No, it was during Corona period, and after Supreme Court judgment, it comes to 37 days.
Now it is 46 days. It is 46 days. Okay. It is an application filed under Section 5 of the Limitation Act for condoning the delay of 46 days in preparing the accompanying second appeal against the judgment and decree dated 24/10/2019 passed by the learned Division 3, title appeal 2 of 2018. This court have perused the grounds which have been mentioned in the said application, and in the opinion of the court, the same constitutes a sufficient cause for condoning the delay. Accordingly, the instant application stands allowed, thereby condoning the delay of 46 days. The registry shall register the accompanying appeal and list the matter at the stage of Order 41 Rule 11. Yes, what is this?
I'm on the behalf of the petitioner to Corporation of India. This is an interlocutory
How much? How
application,
much? Delay how much?
114 days in preparing
29
second
days.
appeal against judgment.
29 days.
No, 114 days. 114 days.
No, 29. 29. Delay condone? Raise
Lordship, we have
the
filed our
RST.
objection, Lordship.
What objection? 29 days you are objecting. As objection, likhi. Objection duly considered, however, did not found it misconceived. Delay condone, raise the RST. 29 days you are. What is this? Given? Service complete?
Yes.
And LCR received?
Yes.
Service complete, LCR received. This is the matter for hearing in the usual course. Liberty, however, is given to the parties to file application seeking early hearing.
In fact, there is a connected appeal.
What?
There is another connected appeal because we have challenged both the appeal to dismissal the suit as well as the allowing the counter claim. That is 165.
That matter is not before me, Mr. Dr. Yes, what is this?
My lord, this petition is filed, my lord. That not on any technical legal ground, my lord.
Huh?
My lord, for allowing the petitioner to repay the amount dictated, my lord, on installment, my lord. Interim order was passed, my lord, to pay 2 lakh rupees, my lord. Accordingly, the petitioner deposited the check of rupees 2 lakh, but the opposite party has not returned the amount, my lord. Right now, my lord, he is able to pay 3 lakhs, my lord. The remaining amount.
Oh, this case.
Yes,
I
sir.
remember long time back.
Yes, sir.
2 lakhs you have deposited.
Yes, sir.
Then?
But opposite party has not returned the amount, my lord.
Why?
Lordship, my client has given me instruction and a prayer before the honorable court to be made that we will withdraw the check, but in May the honorable court it increased the interest, Your Honor, because the interest 14% interest was given upon the principal amount. Once half the amount is 2 lakhs 45.
You withdraw it. You see, you are not going to get the amount once the 2 lakhs has been deposited on that further.
Yes, Your Honor.
There
interest
cannot be an
is-
interest on that amount.
Your
So
Honor.
under such circumstances, you withdraw that amount,
Yes, Your Honor.
interest will come later on.
Your Honor, my humble prayer, the client is made, Your Honor, that the interest may be increased, Your Honor.
Not now. Not now. We are considering later.
My lord, petitioner 1 more lakh.
Huh?
Petitioner want to deposit 1 more lakh.
You want to deposit?
More 1 lakh.
1 lakh. Fantastic. Mr. M. Borman?
I'm sorry.
M.
Your Honor,
Turkey.
humble
The learned
submission.
counsel appearing on behalf of the petitioner submits that the petitioner would like to deposit a further amount of rupees 1 lakh before the learned executing court when
My lord, immediately as directed.
on or before uh, 5th of June 2024. So the respondent herein would be at liberty to withdraw the amount of rupees 2 lakhs have already been deposited if not already withdrawn, as well as the amount to be deposited by the petitioner on or before 3rd of June from the learned executing court. The said withdrawal so made shall be without prejudice to the claim of interest which which this court shall consider at the time of hearing.
Lordship, one more humble prayer, Lordship. Till now, the interest is also accumulated, Your Lordship.
Madam, I have made it very clear
Yes, Your Lordship.
that you will withdraw the amount without liberty will liberate. You will withdraw without prejudice to your claim of interest.
Your Honor, and the last check that they had deposited date was written there. So a new check be issued.
Yes, my lord. This check may be prepared.
Then what remains?
My lord, I have submitted, they have not.
He has deposited that in whose name?
My lord,
Why didn't you deposit in the court?
in the court, check has been deposited.
A check after 3 months becomes useless.
Yes, sir.
Then the order can
Lordship, I have filed an IA civil also, Lordship,
for what?
praying for vacating the order dated 6/8/2022, which allowed them to deposit 2 lakhs, Lordship.
Chalo. Taking into account the submissions which have been made by the learned counsels appearing on behalf of the parties, matters stand adjourned to be listed again on 18th of June 2024. An attempt shall be made to dispose of the matter on the said date. This court have also heard Mr. M. Saikia, the learned counsel appearing on behalf of the petitioner, who submitted that on the earlier occasion an amount of rupees 2 lakhs was deposited by way of a check. However, the check in the meantime have already lost its force. Taking into account the above, an amount of rupees 3 lakhs be deposited before the court in the name of the court, be deposited in before the court, an amount of before the court on or before 3rd of June 2024. The said amount, the respondent herein would be at liberty to withdraw the said amount from the court without prejudice to their rights and contentions, which would be decided when the matter is taken up on 18th.
Obliged.
And then no more check business. Deposit it in the court. Do whatever you pay. Yes, what is this? Document number?
Delay in filing the civil TV.
Yes, what is this? IA for?
My lord, in this case, what happened, my lord?
You are filing objection?
My lord, yes, I have a strong objection, my lord. Yes, my lord, I have objection.
Then file your objection.
Yes, I already filed.
Okay. Why? 3,200 days, why?
We did not get copy of the objection.
You didn't get it? Hello. Lucky. Mr. S.J. Sharma, the learned counsel appearing on behalf of the applicant submits that though the respondent have filed the objection, but copy have not been received. Mr. S. Sharma submits that a copy of the objection shall be furnished to him by tomorrow. List the matter after 2 weeks. Yes. Why steps have not been received by the section?
My lord, application control.
Why you have not taken steps?
One method.
Why you have not taken steps?
Okay, any step is pending. Sorry, I thought getting step is pending. That has come for there are three, there are three IS.
You have not taken steps. So we dismiss this petition. To notice no step taken. It is seen that this court, by an order dated 18/1/2023, have directed the petitioner herein, applicant herein to take steps by registered post from a perusal of the office note dated 9/5/2024. It is seen that the steps have not been taken till date by the applicant.
I pray that only 2 days time will be granted, we will take a step.
As a last chance, the applicant is directed to take steps by registered post upon it is seen that this court had issued notice on 18/1/2023 for taking steps by way of registered post. However, the applicant did not take any steps. Accordingly, this court again issues fresh notice upon the respondent to be taken by way of registered as well as usual within 7 days from today. List the matter after completion of service upon the respondents. What is this matter? Landlord tenant.
No, man, it's not landlord. It is
What is
performance
this?
of contract.
Huh?
This is performance of contract.
Specific?
Performance of contract.
Why it's a CRP?
Yeah, but in the meantime, one order has been passed by trial court rejecting my review petition. They are rejected.
Huh? Review petition rejecting it is against an appeal. How is it maintainable? Forget about other things. Notice nala. You dismiss on that ground. How is it maintainable?
I have not prepared today.
Not
for
necessary.
that matter.
How are you filing this against an order?
There is
Renumbered as
other
22.
matters also.
What is that order? Yes.
There are other
Lordship.
orders also.
So say suit of the year 2000, your lordship. Lordship, besides your lordship, there are
There are other
there
matters.
is review application that
Unnecessary, unnecessary things should not be done.
lordship.
Lordship.
Suit is pending, your lordship, since then.
Review for what?
Review for an order.
What order?
Order, lordship. That order was passed rejecting their application for giving additional evidence. Now these two witnesses, they are no more. They are no more.
Witnesses there.
Yes.
There are other witnesses also. GMC, we have called for a witness from
That-
GMDA. My lord, I explained it. I am going to explain.
Not
What is
necessary,
happening?
Mr. Sharma. You are challenging a review order.
Review order.
Not only review, along with review.
So
No,
why the
original order
issue
also.
order dated demand passed
The
in here,
original order also
rejecting the
can-
review petition passed in so and so.
Yes.
As well as the dated so and so should not be right, should not be allowed. Let us see the. Yes.
Yes, sir.
You against
We have
what?
filed an application for
no,
additional
no.
evidence.
That the review application, your lordship,
Private-
page number 93.
You filed a revision also.
Yes.
What happened?
Revision already dismissed, your lordship.
Huh?
Dismissed for default.
Revision, you challenged that order of 30/11/2015.
Lordship.
30/11/2005. Wait, not necessary. 30/11/2005, you filed a revision before the High Court, this got dismissed.
Lordship.
And you filed a review in 2013, that also got dismissed. And you are filing it. Okay, lekho.
Then,
Heard, Mr. Not necessary.
no, better.
No,
No,
no.
no, no.
I think better you go to
It is
Supreme
not
Court.
like that.
Supreme
It is
Court
not
may
like
help
that.
you.
Not like
Heard, no.
it's not like that. Let the matter
Absolutely
fit for
no,
hearing.
Mr. No.
No,
Now,
let the matter fit for hearing tomorrow itself.
no.
I can explain everything.
Tomorrow is with a cost. With a cost. I'll have it tomorrow, but with cost. Because this is a complete abuse of the process. Mr. Sharma, don't take this court for lightly. This is a complete abuse of the process which you have done. First, you don't take steps. Secondly, this is a matter where you informed the court when you have you have filed this application that the revision application which was filed has been dismissed. Against the same order, you are filing twice. Ask that person, we'll have it. Ask that person to be present in the court tomorrow. Who is that person? Petitioner. Pranab Kumar Das to be present in the court tomorrow. He's from Guwahati. We'll have him tomorrow. Ask him to be present tomorrow. And I'll take him. If he makes a mistake out here, I'll put him to jail from here. Don't worry. List the matter tomorrow at 2 p.m. And at which time the petitioners, both the petitioners shall be present in person. Don't take this court for granted, Mr. This court has further directed the petitioners to be present, taking into account that the petitioners have filed the instant petition, challenging the certain orders which have also been challenged in earlier proceedings, wherein such proceedings have been dismissed and the same is not being disclosed when applications have been filed before this court.
As per order dated 12/5/2023, my lord. Answer notice received where as per postal remind address left the place and I was allowed to obtain proper address and take this step. My lord, I could not obtain
2022 ki ma? 24. You have not taken steps?
My lord, I could not obtain the proper address, my lord. Address
What to
already
do?
left the place, my lord. So
What to do?
time may be granted, my lord, so that
The learned counsel appear for 6 weeks time for taking steps upon the respondent, taking into account the above matters to adjourned to be listed of 6
my lord,
weeks.
there is a IA, my lord. They may be continued.
Not at all. You have not taken steps.
My lord, address is left the place, my lord. This is the problem. My lord. I have taken steps, my lord. Address is left the place, my lord. They are only
Interim order passed earlier. Yes, what is this?
Exponent number 2 is not necessary part because we are challenging quantum, my lord. That's why, my lord. And LCR received, my lord. Let the matter may fix for hearing, my lord.
Service complete.
Complete.
Service complete and LCR having been listed, list the matter for hearing in its due course.
Let's see.
Yes.
Kindly, last of it.
Huh?
Last of it.
My lord, respondent number,
Your file wakalat na ba?
no, my lord, we did not, it's on the, we'll file for
You're
respondent.
filing it.
We'll file, my lord, but did not receive yet. The party sent already.
Mr.
But
A.K. Hannan.
respondent
submit.
number 8, my lord, has been expired.
Who?
Respondent number 8. So
8 has expired.
we struck out.
Mr. A.K. Hannan submits that the wakalatnama of the respondent number 11 would be filed within a week's time. However, he submits from information that respondent number 8 had expired.
Yes.
Learned counsel appearing for the appellants submits that he would take appropriate steps. This is the matter of 2 months.
My lord, I filed follow come up for the petitioner only today. So this may come after 2. The earlier that has been changed.
Yes, you have
Filed the follow come up today.
Oh, new one.
So after 2 weeks,
Mr.
NH Majapi,
N.H. Madhurya appears on behalf of the respondent of
not
petitioner,
for the petition,
and Mr. AMR
AHMR.
Chaudhary appears for the respondent. The registry shall show the name of Mr. N.H. Madhurya in the report in English. This is the matter again on 19th of June 2024. Are they in same order?
No, my lord. No.
Then what is the urgency?
No, I think.
List the matter after the sum of process.
May please, Your Honor.
Mm.
I thought in this case for restoration of RSL lordship, I took the step on 17/8/20
Service not complete.
Not-
2, 3, and 10 had died.
lordship.
From the office note dated 16/5/2024, it reveals the service upon the respondent numbers 2, 4, 5, 6, and 7 is not complete. Further to that, as regards respondent numbers 2, 3, and 10, it has been mentioned that the same had expired. The said respondents have expired. As regards the respondent number 9, their address is insufficient. Mr. R. Sharma submits that he would take appropriate steps in that regard. List the matter after 2 months, 3 months. 29.
My lord, the appellant till date did not did not took step upon the respondent number 6A to 6E.
Yes, you have taken steps, note step. Why? Okay. Mr. R.S. So appearing on behalf of the R.S. R.A. Chaudhary, the learned counsel appearing on behalf of the petitioner submits that appellant submits that the name of the respondent number 6A to 6E and 7 to 7C may be struck off. Full stop. Taking into account the state submission, the name of the respondent number 6A to 6E and 7A to 7C are struck off. Taking into account that they are pro forma defendants, respondents in the instant application. The counsel appearing on behalf of the appellant is directed to file a fresh memo of parties before the registry of this court by 27th of May 2024. And on the basis of the said memo of parties, the registry shall make necessary correction of the records and also update in the CIS list. Further to that, it is also seen that the steps, the service is now complete. And LTR has been received, for which the appeal can be listed for hearing in its usual court. Parties are given the liberty to file application for early hearing.
There is an order for not to alienate your.
Huh?
Order of
No, This court have duly heard the learned counsel appearing on behalf of the petitioner, appellant, as well as the respondent. Taking into account that the accompanying appeal has already been admitted and this court have already fixed the appeal for hearing in its usual court. This court makes the order dated 16 that directs that the order dated 16/6/2023 passed in IA C-1679 of the 2023 shall remain in operation till the disposal of the appeal. Full stop. IA stands closed.
Right.
Those statistics for coordination of delay, I have been informed that the appellant has passed away, so I did to file appropriate appeal.
Somebody has filed wakalatnama?
I think it is the.
Did he
appellant
inform
has
you?
asked whether the respondent,
Has their names been shown?
their name has been shown.
The respondent's counsel?
Yes.
You were sure the appellant, who died?
The appellant,
Who appellant? Mr. A. Because the learned counsel appearing on behalf of the appellant submits that the whole appellant has expired. The applicant has expired. Under such circumstances, he submits that he needs to take steps. It's the matter of 2 months.
how do you apply?
Yes, what is this condonation?
My lord,
How much?
my lord, 5% days.
Huh?
5%.
Objection?
Yes, my lord, I have filed, my lord.
You have filed.
No, I have not filed, my lord.
Mr. What's your name?
M.A. Chaudhary, my lord. M.A. Chaudhary.
M.A.
M.
M.A. Chaudhary, learning counsel appearing on behalf of the respondent submits that he has objection to the application seeking condonation of delay. Lists the matter after 3 weeks. After the replies be filed. Yes, what is this?
No. There has been filed against the order of Revenue Board, the Board of Revenue.
Huh?
We have challenged the order passed by the Board of Revenue, cancelling my mutation.
Huh.
Against that, so wrongly because decision has been filed.
How do I convert? How do I convert it to 27 to? Tell me. Accordingly, he prays that he may be granted time to file appropriate. I have to convert. How is it possible to convert 227 to 226? To withdraw and file a fresh one, and the period during which this is there will be excluded. Period limited. There's no limitation to.
No limitation.
So the learning counsel appearing on Mr. S. Sahu, the learning counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant application under Article 227 of the Constitution, with a liberty, however, being given that he may file an application under Article 226 of the Constitution challenging the judgment and order dated. What is this order? This order? Any issue where the dispute involves the state of the was the evidence that claims that the issue all litigation. You are appearing
Yes, madam.
for all.
Yes. Earlier there was 59 days delay, my lord. One set of my lord, I withdrawn, my lord. So
We
I
do
said,
one thing, we convert it. And because this small order, I don't think it will be. We do one thing, we'll have this back on some other day, on which date we convert and then do exercise 226 and decide. Better, huh? Because again, 2015, we are again 9 years, again go back.
2001 title suit.
No, filter. At the
Here
at the
it is,
request of Mr. S. Sahu, the matter stands adjourned to be listed again on when? Urgency? Urgency?
After 20.
Urgency is there? No.
We do not have day much.
We have urgency.
Yes, madam, unnecessary case.
Unnecessary pending.
2015.
15 on 20th of June 2020. Tuesday.
All due respect.
What happened?
Let me take the judgment. Start at page 33.
Page?
Page 20 is the judgment start.
What have I done?
Para 10.
Era?
Para 10.
Yes.
If I may read. This court has taken note of the impute communication dated 1/8/2018 which rejected the request for joint action report on the ground that the petitioner had neither got the letter of intent from the National Horticulture Board nor got online registered with the National Horticulture Board up to 39,000 for claim of direct subsidy without any alloy from the National Horticulture Board. So it is the case of the petitioner that the petitioner applied on but this is at page 30. 30.
Yes, but
Down below.
so it is the case of a petitioner applied on 30.
But the state application is an application for issuance of the LOI, which is apparent on the reading of the state application of this part. The state application was, however, rejected on 3/4/2007 on the ground that various documents were not placed and was returned. The petitioner did not challenge the state section of the application for I take up the letter dated 33/2017, which is at page was
30?
Page 16. The letter dated 33/2017. Against which the order was page 16.
60.
60. I have annexed the entire. It's the page 20 of the report.
Yes.
So this is the letter dated 33/2017. So the next page got 33/4/2017. That's that. If I may read
34/2017. Yes.
See this with the reference your letter dated 33/2017, where the by you have submitted project proposal for extension of cold storage under scheme and as per the scheme guideline, preliminary examine the project following document setting. So down below. If in view of above, please find return here with application and other documents along with demand draft.
Yes, what is the if you take so much of time for a review, this is the case for review dismissal and go and appeal. Dismiss it. How much time? Huh? Absolutely no. This is not a case for consideration. You have consideration, go to the division bench.
With all due respect, sir, the
No.
other point which was raised by my thought, that chapter 2 guidelines were not put by the person. Because the
I'm not concerned. I'm on a question of review. This is not.
Milord,
Anyway, some other day.
Milord, for the timing.
This is the matter of the
Milord,
3
kindly
weeks.
allow me.
No,
Milord, the other
no,
point was
Mr.
that-
Betala, no, nothing doing.
Milord, the
You
second
don't
point-
have a case.
Milord, the second point because your
You
lordship
don't
has
have a
made very-
case.
Milord, the
No,
person
Mr.
did not reply,
Next.
then that is not record.
Sorry.
So that is not record.
I'm not dismissing it. That is the good thing I've done.
Milord, Milord can check it.
For what?
That the second point which your lordship has raised to the earlier council, that the chapter 2 guidelines you have not shown, that forms part of the restriction. But that is what your lordship.
That doesn't fundamentally change anything. Go to the division bench. Division bench will be
Yes,
there.
my lord, Milord, we are not doing with the
No.
Milord,
Okay, lift the matter again on when.
Milord, as my lord is any date, Milord, convenient to my lord. If it can be on Wednesday, Milord, I'll
No,
only that part because it was
Is the matter today? Is the matter on 27?
me, Milord.
27?
It was
Just
because
after
of
the
the
motion.
assisting council, Milord. He
Huh?
could not place the proper fact. That was that Milord, I say that the person should not. I will bless.
You file objection, Mr. Alam?
My lord, I have had it.
What is this delay?
My lord.
This is for what?
Injunction, my lord. Injunction application.
We'll take it some other day.
Yes, my lord.
They have
Even-
admitted
My lord, in my application, my lord, I have admitted we don't have any intention for question of third party right.
This is RSA. Both RSA.
RSA, my lord, better also IA number 1164.
Injunction for what is the asking?
They have fill up the land. They have admitted they have fill up the land. How to prevent farm.
You have filled up.
No, my lord, only my residential portion, my lord, which is low lying, my lord, and flood water used to drain inside the house.
Have you completed?
only that much has been.
Now, what has been alleged, you have completed.
No, my lord, allegation is, my lord, I have developed the entire land. That is not that I am not admitting that allegation.
Okay, what are you admitting?
My lord, only I have filled the my residential house, which is low lying.
Very well.
And my lord, they have also further.
Now he wants an injunction. What
Let
to do?
Let him grant injunction, my lord. I don't have it because further allegation is this. I am going to create third party right. That is not my intention.
You are?
I am going to create third party right over the land. That, my lord, on a affidavit, I have stated I don't have any such intention.
Hello, we'll take it up on some other day.
My lord.
List the matter again on 29th of May.
Can it be met on 30th, my lord? 30th, my lord.
30th not possible, 31st.
31st. Much obliged.
Is that first time? Is that first time? Is that first time? These IAs are for the first time.
Yes, Lord.
Okay, take the issue notice for you. 37, 38, issue notice. By 6 quick steps by registered as relative. 49. Service complete. Service is complete. 122 days. Take it up on 29. When? Let us take it on 24th. 24th? 49. Oh, that notice has been issued 6 weeks. Yes. Okay. List the matter to list the matter after 2 weeks. Stay as the You have filed? Okay, interim order. Okay. You have filed the affidavit of service, na? Okay. List the matter again on 22nd of July 2024. Interim order passed earlier shall continue till date. Yes, what is it?
I filed an IA under order 13-9. So in front of the two original certificates that have been kept as a part of the FCI.
Very. Yeah.
Yes, sir. Actually, that has been exhibited as Exhibit 1 and Exhibit 5. And the London trial court, they kept it as a part of the record.
This RSC is disposed?
No.
Pending, Lord.
It's pending.
What do you want?
Lordship, I'm taking a leave of this honorable court to get back the original fields. So Lordship, by giving the certified copy.
Chalo. What do you have? You know objection?
Otherwise, he has to submit two copy of the photocopy, Lordship.
They can keep a photocopy. This is an application under Order 13-9 of the Code of Civil Procedure for return of the original admitted documents which have been submitted before the learned trial court in title suit number 23/2009. This application has been filed by the appellant stating that the documents, more particularly the sale deed number 2165 dated 21/5/1985, as well as the sale deed number 1008/1992, which have been exhibited as Exhibit 1 and 5, are required by the appellant for certain important reasons. First, this court, taking into account the said submission of Mr. G. Bordlow, permits the return of the original of those Exhibit 1 and Exhibit 5, subject to the registry comparing the said exhibits with making proper the registry keeping keeping photocopies, keeping true copies of the said documents by comparing with the originals. The same shall be done within 15 days from today.
Objection.
I
Objection.